Yes. And do we have Mr. Dombrowski present?
It appears that he is.
I am present, Your Honor.
All right, thank you, sir. So I had a question.
Sure.
Did Mr. Dombrowski file his taxes before that February 21st, 2023 order was entered?
He did, but also if you take a look at the original child support order that was entered on July 19 of 2022, paragraph 19 provides that in even years, my client has the right to claim the child. So 2022 was an even year and my client should have been able to claim him. But the reality is that given the 401k disbursement previously by Mr. Dombrowski that's been carrying over under COVID relief, as well as the 401a forfeiture for my client, and the community benefited from both of those. Technically, we think that it is appropriate, particularly in light of the amended temporary child support order, that an amended joint 2022 federal and Oregon state tax return should be filed, because that's going to decrease ultimately what these folks owe to the federal government. My concern is that at this juncture, Mr. Dombrowski has already received, I'm assuming, the refund from the IRS of $1,897. And according to his tax return, he owed $473 to Oregon. If we amend, then there would be $15,076 plus any additional interest and penalties from the from the 401a and 403bs, as well as we're proposing that he pay the $1,686 that he would owe Oregon, because that would take into consideration what he had already received on the federal refund that he wasn't allowed to file. And then we do have money sitting in the in my attorney trust account from the party's home sale. We are proposing that those monies, or that the amount owed to the feds, be paid from the home sale proceeds so that they don't continue to accrue interest.
Mr. Dombrowski?
Yes, Your Honor. I did make a mistake. I thought I was the even years, and I proposed that Ms. Dombrowski, we can switch, and Ms. Dombrowski can claim odd years. The fact that Ms. Dombrowski defaulted on her 401k loan, I should not be subject to that money. I have 2 401k loans out that I'm still repaying, and I don't. Also, the tax refund that I received, I did not receive it. Ms. Dombrowski got it. So I did not receive 1 cent from the federal government. Ms. Dombrowski received it. And I don't feel that I should have to file jointly.
All right. Ms. McLean, thank you, Mr. Dombrowski. Anything else, Ms. McLean?
I would just indicate that I think he is accurate that Office of Support Enforcement, or Washington State Support Registry, swept his refund, because he currently owes my client, I think, upwards of $20,000 in arrears on child support and spousal maintenance under temporary orders. So I think that is accurate. Regardless, he has sufficient funds, and if anything, he should have an obligation to pay, since he filed in violation of the orders. And then if you want to hear more on the 401, so the 401a loan was taken out prior to their separation, and those monies were used towards improvements for the home prior to it being sold. So the community did reap the benefit of that, because ultimately the home has been sold and there's money sitting in my trust account from the sale of that asset.
Your Honor, may I say something?
Yes.
I have submitted to the court, I have submitted to Ms. McLean, that all my temporary orders of support are based on COVID, the time of COVID. I work 6-7 days a week, every week for almost 2.5 years. I do not work that. I've showed my pay stubs, and I do not make that amount of money. I currently, as of right now, my biggest paycheck for 2 weeks has been $560. I can't afford to pay my mortgage, or it's not mortgage, it's a rent. I can't pay my rent. I can't pay my truck payment. I don't even have hardly enough money for food. So I don't know where Ms. McLean thinks I'm going to get all this extra money, because I don't have it.
I would just note that child support and spousal support modifications are not before the court. Mr. Dombrowski has set himself up for what's being withheld because he's failed to voluntarily pay before WSSR started collecting it, and that's why he's thousands of dollars in arrears.
That is incorrect, Ms. McLean.
Oh.
I worked with support enforcement to make sure that it was taken out. And just because the company I work for, the headquarters for payroll is in Atlanta, that's not my fault. But Mr. Law from support enforcement, he said that I was very participant in helping get those monies going.
Okay. Well, I'm not going to find any fault there as far as whether you voluntarily, I'm going to assume that you voluntarily got everything that needed to happen for those payments to start coming from your paycheck. I would agree with Ms. McLean. Child support is set where it's set, and that's not before the court. If there is a concern that that's incorrect, then that other action needs to be taken by one of the parties to try to address that. This is, I did review everything in this case. I did review the order that does indicate that the even years would be to the petitioner, odd years to the respondent. It had been in place for a few years at this point. And I'm going to approve the order as presented by Ms. McLean.
All right, thank you. And we did provide to Mr. Dombrowski the proposed amended federal and Oregon state tax returns. If he wants to just sign those and email me signed signature pages, then we should be able to get that filed by the October 31 deadline.
On for
Right. Thank you.
A number of matters. Both parties filed contempts against the other, child support and a parenting plan. Ms. Olson filed a declaration very late yesterday. I intend to object to it. It does look as though it's been an odyssey. So if your honors reviewed it, it contains accusations that weren't in the prior motion that we hadn't had a chance to respond to. So if the court has reviewed it and would consider it, then I'd be asking to continue the matter.
Let me. Okay, there was a filing that it looks like it was dated 10/23
Yes, Your Honor.
by Miss Olson, and it does not appear that it made into Odyssey when I reviewed the matters.
Okay.
So
Then we can wait.
I haven't reviewed it. If Miss Olson, if you want me to review that and consider it, I'm likely to set it over so the opposing party has an opportunity to respond. So if that declaration affidavit that you filed yesterday, you want the court to consider, then
yes, that would be fine. I got a declaration from them in the mail on Friday. The last couple things I've received from the attorney have been, via the mail. So I felt like I needed to respond to it. And so, I mean, they're not serving me. Do declarations you don't have to serve like via, a courier or anything. They can just come in the mail. Because I received Mr. Olson's declaration in the mail.
it looks like the certificate of service that I have was that they served it by way of the U.S. Postal Service as well as via email on the 17th of October. So,
okay.
Mr.
All right. I didn't get an email of that one.
Okay.
I just got it in the mail.
Mr. Baldwin, how much time would you need?
I would like it to be heard as soon as possible, Your Honor. I don't know if there's space. Next week's probably full. If Your Honor wants it over 2 weeks, that's the furthest I'd like to go.
Tiffany, can you help with that? I don't know that next week is full.
Oh.
I think we actually may have space next week, but I'd like the clerk to confirm.
Perfect.
Not full.
It's not full. So we can put it over just 1 week to the 31st. Does that work?
We can do that. I'll get something out by the end of this week. We did get an email response from our client. We got it to him when we received it yesterday, but need to get a declaration together and filed, but we'll get it submitted as soon as possible.
Okay. So then, Mr. Baldwin, Ms. Olson will set all of the issues that we were to hear today over 1 week to the 31st at 1:00 p.m. All right.
Ready, Your Honor.
I'm assuming all the parties received the GAL report. Sorry, my computer's running extremely slow. So that was filed on the 13th of October.
Correct. We did receive that. My client has reviewed that as well, and we're ready to proceed today.
As are we, Your Honor. I do believe we did receive email contact from the jail. There may be some additional information. I defer to her to find any additional information in the court. And then I think the parties are prepared to proceed.
Ms. Height, is there any, assuming you've shared it with both counsel, is there something supplemental to your report from the 13th that you'd like to relay?
Yes, there is, Your Honor. I did notify both of them of my visits with Mason subsequent to the time this report was filed. I'm going to look at my notes if that's okay with Your Honor. I would note that in my report, every time I spoke with Mason, he was very clear from the very first statement he made to me to the several conversations. I would say we probably had, I was going to look that up and give you an exact number, maybe 3 or 4 phone calls, and we've had a couple of in-person visits, and he always was very positive about what he wanted, that he wanted to go to Dad's, and I delineated much of that in my report. So I was quite surprised when on the 18th, on October 18th, a little after 2 o'clock, I received a message, "I need to talk to you," a text message from him. And when I called him back, he was crying. He was quite emotional. It took him a while to gather himself, and he said, "I want to change it. I don't want to go to Dad's. I can't leave my friends." I'm reading now from the notes that I took specifically. I can't fully be myself. I can't fully be myself. Mom has been trying, and our conversation was rather sketchy because he would break down and cry and need some time to gather himself. He said, "I love both of my parents." We talked just a little bit more generically, and he began to calm down. So I told him that I was going to make sure the court heard what he had to say. I texted with him on the next day on the 19th, because I was still concerned about how emotional he had been. Just a quick text during his school hours, "How is your day going?" And he said it was going okay. Monday, I visited with Mason at the school, and he was emotionally in really good shape. He was able to clearly talk to me about how things were going at school. Things were good. And then with a kind of a grin, he said, "I lied to my soccer coach," and pulled up his pants and showed me multiple soccer bruises on his legs, and said that I lied to my coach. I told him I couldn't go to soccer because I was hurt, but I just didn't want to go. All of that was preliminary to getting into what he really needed to talk with me about. And what my notes tell me he said was, "It's a hard time, and it will just be harder. I don't want to leave my friends. When I told them I might be leaving school on Tuesday, they said they don't want me to leave, and I'm the one who makes school good for them." He said, "I don't want to try it. I can be better. I can get better by myself." He then said, "School is more relaxed at Mom's. School things are more relaxed at Mom's. If I mess up at school at Dad's, I would get blamed for it." Then he talked quite a bit more about his friends and things he wanted to do about his friends. When I asked him about how he happened to be telling his friends that he would be possibly leaving school on Tuesday, which is today, he couldn't or wouldn't explain that to me, and I didn't press him. He just said, "Is that going to happen?" And I told him, "I don't know what's going to happen. I don't make the decisions, but that I would be very sure that Your Honor heard precisely what he had told me today." And that I assured him that both of his parents love him, and we left on very good terms. That was yesterday about this time of day. I haven't talked to him since then. So besides my report, that's the supplemental information that I have for Your Honor today.
Thank you. It's pretty significant. Does either counsel have any questions of Ms. Height?
No, I don't think so, Judge. I think she did as per Ms. Height's usual self, did a pretty thorough job on that. Did get that information. My client was aware of that. He reached out to me initially once we received that. We've had communication between Mr. Baldwin and myself, Ms. Height and myself, and obviously my client and myself regarding that. I do have comment on that. I think it's pretty transparent as to what has occurred, but I'll save that for my arguments.
Mr. Baldwin.
I don't have any questions for Ms. Height.
All right. Thank you, Ms. Hyde. I appreciate it. All right. We'll start, Mr. Baldwin, since your client's the petitioner. I don't have a motion before me, so.
Yeah, I believe we were here initially because Mr. Zandy made a motion for adequate cause. I think there's definitely a dispute as to what the predicate factor is here. I anticipate Mr. Zandy's viewpoint is going to be that my client had a hand in putting the child up to making a change. As evidenced in the GO report that was written, my client's maintained throughout the proceeding that it's her opinion that father has been in some ways insinuating himself and his desire for a change onto the child, as evidenced by what up until very recently was a relationship with my client that was fairly fraught with animosity as identified in the GAO report. To say, as Ms. Height did, that he was consistent initially in his desire to move or relocate, I think might even be an understatement as to how significant or severe behavioral issues were at times in my client's care after visitation with father. There seems to be, at least in some regards, the consideration of concerns for ongoing issues for this child while in mom's care. And I don't doubt at all the integrity and veracity of those concerns. It seems that to the JAL, both parents recognize that coming into this, there were circumstances that suggested Mason was in crisis. Ms. Height recognizes in her report that, at least in some regards, given the age of the child, his will is not necessarily the most controlling or the only factor the court considers, but that was adamant and clear in the GL recommendation that he did not want to continue residing at my client's, with a significant amount of the accusations that give rise to the recommendation of changing placement coming from Mason himself. And that's a complete 180 here with what he is indicating to the guardian ad litem. He came home from a visit with dad. And again, we're in a situation where neither party, because there was this ongoing uncertainty, filed any declarations or additional information. As I said, I anticipate Mr. Zandy's argument in some way would be that my client is the one who instilled in Mason that he's likely to be moving as a means of some sort of emotional manipulation. And we would dispute that vehemently. There were issues as recently as last week with Mason not wanting to participate in school or counseling services because none of it mattered. He was moving in with his dad. And my client has maintained throughout, as clear in the JO report, that came from dad. It is unfortunate that it is a very recent change where we don't have more time or record for the court on whether or not Mason has turned a corner with his behavior at school. The GAL report, and I believe conversation with the GAL school, was not a primary consideration or concern necessarily in the location because he wasn't doing particularly well in school, was having behavioral issues in school. And that seems to be a significant factor in his decision-making here and wanting to stay where he lives. Some of the statements to the guardian ad litem certainly are concerning, that it's just going to be harder if he's at his dad's. If he does anything wrong at dad's house, he's going to be blamed for it, is a telling and concerning statement from a child about what would be ongoing at father's house. I think the underlying issue here is clear, both in the report and in the statement by Ms. Height that this child does have two parents that care very deeply. And our position is that the report, taken in concert with the current wishes of Mason and I think a fairly significant turnaround and change in his behavior in the last week or so in mom's home, that a change in placement is not necessary. And we'd ask the court not to make a change. If the court's going to make a change, I think that the parties live in Rainier and Woodland. 50-50 would be very difficult, and jail does indicate that there are issues in the party's ability to co-parent that might make that not the best outcome or decision, that whichever parent is the non-custodial parent should have more than standard visitation, that the cooling off period that was originally proposed would no longer be necessary, and that visitation should be more regular than just an alternating weekend for whoever the non-custodial parent is.
So I guess just to summarize, there was a adequate cause motion that was ultimately granted. Is your client's position that essentially the parenting plan that was in effect should just remain in effect?
Yes, Your Honor. At this point, I think what the adequate cause was agreed, and it was set over for the court to consider whether or not a temporary parenting plan was needed. Our position would be no change is needed at this time, and if the court is going to make a change, that it should result in significant time for the non-custodial parent if it is changed to the father, more than a standard plan. That a lot of those concerns in the jail report don't appear to be active or ongoing based on the new information, but that we don't believe there needs to be a change, at least on a temporary basis, that doesn't prevent the matter from moving forward with adequate cause having been found.
Okay, thank you for clarifying that for me. Mr. Zandy.
And thank you, Your Honors. Court's aware I do represent the original respondent, the moving party to the petition for to change the parenting plan, namely Garrett Haugen. And it's our position that we've got the obvious signs of a 12-year-old who is in crisis. It's our position that we're at a very significant crossroads in this young man's life. I think that is parlayed by the findings of the GAO. I think that is evidenced by the information we have provided you, which is very significant for Mason's school. It's evidenced by the information that my client details for you. And I'll go ahead and say it. We were somewhat surprised by some of the findings in the GAL because that surpassed a lot of the issues that we even knew were prevalent. The court went back to the onset of this filing. And again, I think the history is somewhat important in this. This is just not about what a 12-year-old wants to do or does not want to do. That is one of several factors that the court considers. But if you look at the information, that's dated back to the spring, this is from the teachers. This is from the same school that referred and called CPS due to concerns about Mason and his care for his mom. These are the same people who report. And it's in the email that we provided to you at the onset of this case back in August that stated in very unambiguous terms that Mason wants to live with dad. Mason is more comfortable at dad's home. Mason has expressed a safety net at dad's home that he just quite simply does not have at mom's. He tells the GAL that not once, not twice, but multiple times over the course of the investigation. What happens on October 18th? Last week, and again, on a day or two after the GAL report was published, we get then grumblings, and my client is contacted by the child. His wife, or excuse me, fiance, is contacted by the child and says, I don't want to live with you guys. I changed my mind. The child is in tears. He is emotional. My client hears things in the background, which could have been a television set, could have been his mother. We don't know. That's guesswork at this point. But what we know is a child who has been adamant about living with dad, adamant that dad's house is where he wants to be. All of a sudden, within moments of the GAL report being published, says, no, in close to hysterical terms, I want to live with mom. Can't really express the reason for that, but I just think it would be better. We look at the GAL's findings and we go back to some of the investigative work of Ms. Height, and we see that there is some undertones that are pretty clear that mom is exposing the child to the litigation. Mom is showing pleadings. Mom is showing proposed parenting plans. Mom is emotionally sabotaging this child, manipulating him to the point of what we could call only as alienation type tactics. The same type of thing that we absolutely despise when we're practicing this type of law and looking at these types of facts. Mom was doing that throughout the course of this case. This is a case which these aren't new issues. These are issues that are going back several years that we initially had back at the onset of COVID, prior to argument, prior to all of that. The history of this is something that continues to fester and continues to boil. But this is something that has gotten worse over the past 3 years. This child, again, is in crisis with that. If we look at what was provided to you and the initial allegations of my client leading up to this point, he states for you, and it's ironic when you get mom's response to this. He tells you about the conditions of the home. We give you the information from the schools. We give you the information about the CPS investigations. We give you the information through documentation. We gave you just a snapshot of that, which Rainier schools finally reach out to my client after he has conveniently left off the contact list for mom and say, your kid has some major issues and recommends a change. The school goes so far as to say, please, this needs to be presented to the court. We are presenting this to CPS based on what Mason is coming back and reporting. Mom, by the GAL's account, has at least 10 boyfriends. The GAL in her report cites that she had to actually kind of make a flow chart of those boyfriends. Some of those boyfriends are beating Mason with a belt. Others are having extreme interactions with Miss Krevling. Others are sleeping in the same bed and having sexual relations while Mason is in the room with them. This is not a conducive environment for a 12-year-old. 12-year-old then goes through mom's phone and sees the pictures of mom sexting with one of these boyfriends and nude pictures of his mother. Think about the trauma to that of a preteen boy who's on the verge of puberty. Mason then goes to school and has the girlfriend in which he's sending nude pictures to based on what he sees on mom's phone. Mom, in some kind of an emotional response back in June, leaves the kids at home, goes out to the middle of the woods in the bushes and the railroad tracks, and essentially goes off the grid for a period of time because she's on the verge of breakdown. Mom repeatedly moves in violation of the relocation statute. Mom unilaterally decides what the parenting plan is going to be, despite what's on paper. My client details for you, and there's very little response for Ms. Krevling, that it's his weekend with Mason, and basically he's on alert for whenever, although the plan says 5 o'clock, it might be 7 o'clock, it might be 7:30, it might be later, because mom does what mom wants to do. Mom leaves him off the contacts from all of the doctor's information. My client had no idea that the child was even on ADHD medication until after the fact. The school had no idea that my client even existed until he said, listen, I'm concerned about my child. He wasn't even on the contact list at the child's school, the same school where there's an IEP and a 504 plan in effect. Mom then says, well, I don't like what the school's doing. I'm going to uproot this kid again, and we're going to go live in Longview. She doesn't provide relocation notice. I'm going to take the kid and go to Three Rivers Christian. Again, without notice, without input from my client, she unilaterally dictates to him what's going to happen. Now, the latest and kind of the last straw to this is we're going to latch on to Mason. We're going to emotionally manipulate him. Again, a 12-year-old child who wants structure, who wants love, who wants support from both parents. I think that's obvious. And she said, and influences him again to give the input. One can only assume, because this is the same parent who's been showing him pleadings throughout this matter. And this is the same child who has way too much information about this litigation, which the GAL surmises comes directly from mom. We then have these games that mom decides to play, and the GAL refers to that as a prank. I don't know what it is, in which mom is going around town, or we suspect mom, it certainly looks like that through the investigation. I'll let Ms. Height comment on that. Plants keys around town that says, if found, please contact my client, puts his personal information, including his phone number and his address on there, and plants those throughout town. So he's getting vague, bizarre phone calls from people who have no idea what they're talking about, saying they found his keys. From what we understand, that's some kind of a scam. I have no idea. And what does mom do? Just kind of shrugs her shoulders. We get the information from Mason. Mom doesn't deny it, but she also doesn't admit to it. She says, well, it could have been somebody else. It could have been Garrett doing that to himself just to look better in court, which seems highly bizarre and highly unlikely. So we have all of these things. All of these have an impact on the child, who tells you what? To the GAO. I found a bag of keys on my bed that I no longer use anymore because I sleep in a couch in a very crowded, very small home. That's filthy, by the way. And those keys all have my dad's information on. So we can draw certain conclusions from this. Part of this issue is looking at who's being candid and forthright. And I think that's clear that mom just doesn't have any ability to do that. Mom has not done that. And mom continues to kind of spin this woes me web of trying to gain sympathies for that, for her actions in which she has just not performed as a parent. Would also mention, and I think it's abundantly clear, when I say this child is in crisis, when I say we're at some kind of a fork in the road, changing schools now is very important to do that. And again, if we look at the respective households of the parties, that gives further evidence and credence to that conclusion. My client lives with his fiance. He lives in a spacious home in Woodland. He has no plans to move. He is stable by all accounts. He's financially stable, emotionally stable, and relational stable in his ability to provide for this child, who says initially, and has said throughout until the last couple of days, dad's house is great. I get along with my stepbrother and my stepsister. I get along with my soon-to-be stepmom, and we do fun things at dad's house. Mind you, mom's suggesting that the child now again uproot and move to Longview and move to Three Rivers. Uprooting this child in the midst of the school year, although we typically don't like to see that, makes no point and makes no difference at this point. Child is not doing well in school, hasn't done well in school. We've given you information from Rainier that shows he's at a 3rd grade reading level, and he's now a 7th grader. To suggest these friends, and again, which kind of comes out of the blue, want him to stay, I'm sure there's some reluctance to that. All 12-year-olds are going to be a little bit leery of going to a new school, going into a new environment. But the fact remains, the bar is so low for this child right now because he hasn't performed academically. He hasn't performed socially. And the friends that he has have not been good influences. These are the same friends who have kind of festered and manifested this issue with, again, the lewd pictures that Mason sent. This is the only option at this point. And again, I'm somewhat concerned when mom comes forward and says, well, dad's doing these things. In her proposed parenting plan, she lists my client as having 191 factors. She alleges alcoholism, domestic violence, alienation tactics, when if you look at just the black and white of this picture and what comes from the school, what comes from the GAL, and what comes from factually based, non-biased third parties, it shows mom is doing that. Mom is the one that doesn't return the child. Mom is the one who doesn't give my client his summer visits in 2022. Mom is the one who is showing this child all this information related to the court action, which again is despicable. Mom is the one who doesn't include dad on the medical decision-making, doesn't include him with the schools, doesn't give him notice or of anything. Those are alienation tactics. That's withholding. Those are contempt measures. We don't want that. We just simply want what's best for this 12-year-old kid, because again, we are at a very significant crossroads in Mason's life. And the only suitable environment for him at this point is my clients. I think it's very clear to see what's going on. I think it is extremely sad. I think we are fortunate that we have a place where Mason can go, where he can hopefully thrive. He can't do any worse than he's doing currently at Rainier. And again, that's evidenced by the teachers. I cannot recall a single case in which I can have a school or a teacher reach out to the amount of time because they're so concerned about this child as Rainier has over the past year and a half. They've reached out to the CPS, they've reached out to mom, they've reached out to dad, they've even given the child special access to phones so that he can communicate with parents on a as-need basis and come forth with some pretty damning information that shows mom is simply failing as a parent. That needs to change. And again, this isn't about what my client wants. This isn't about what mom wants. This isn't about what I want or Mr. Baldwin wants. This is about what's best for the child. And at this point, the move is not only justified, it's the only option. So that's where we stand. We are asking that you approve the original relief that we requested back in the summer. We're asking you to adopt the GAL's report. I think that makes sense. By no means are we trying to cut off contact between Mason and his mother. But the reality is her home is not suitable for primary custody. It's just not. You got a 12-year-old sleeping on a couch looking at naked pictures of his mother on her phone. And again, that's completely inappropriate. So given that information, given the GAL report, I put very little stock in what happened over the last couple of days, other than it's further evidence that shows one of these parties, and I think it's clear to see which one, is influencing this child or attempting to by manipulating his 12-year-old brain into thinking that it's his decision, that the pressure is on him and the onus is on him, and it's not. This child is not a caretaker for his mother. This child should be deserved to be allowed to be a child, and he's 12 years old. We're asking you to adopt the change. We're asking for the relief cited, and we're also asking for a mutual restriction. And my client certainly agrees to this, that nobody involves this kid in this action. There's no review of pleadings. There is no negative talk about the other parent. They both love this child. They just have very different ways of parenting. That's great. That's a start, but they need to quit involving this kid in adult matters and making him think it's his choice, putting him in the position of having the emotional distress that he's had over the past week since the GAL report has been published. I think that point needs to be clear to everybody involved. And I think this child is in desperate need of change. And I've got real concern when the GAL report cites eating issues, when the GAL report cites concern about this child potentially harming himself or others. That begs that whatever the current arrangement is not working. That's our request. I think it makes sense given the information in front of you, and we're asking you to adopt our form of relief.
Thank you, Mr. Zandy. Anything else?
I have a response, Your Honor. I don't know, Ms. Height was unmuted. I don't know if she had anything to say before I did, but.
Go ahead, Mr. Baldwin.
Right. And so with respect to the argument relating to the prior pleadings, that we did agree that there was a basis for the court to consider adequate cause. It was likely given the accusations and the concern from the school that the court would make a finding of adequate cause. We don't agree with a multitude of the assertions or accusations in the father's pleadings or in the argument. With respect to school issues, his report card that was submitted as an exhibit showed that he was at or approaching grade level. His standardized test scores showed below grade level. That was the basis for that concern. Unfortunately, I think it's been relatively common, especially since missed time for kids during COVID, where standardized test scores have been below grade level, but the teacher's actual report card was showing, at least in what was able to be submitted by either party, in English specifically, a 3 on the scale of 1 to 4, where 3 is meeting standards, grasping the level of the grade. So I think the adherence to the standardized test score alone is not an adequate representation of where he is academically. He certainly has issues. I think it's interesting that the significant majority of the accusations against my client come from Mason, and a situation where when he wants to go live at dad's, he says my client's the worst, and when he doesn't, he says things are fine. And he's the reporter for a good portion of this, unfortunately. As far as the school was completely out of line in the situation they put themselves in here. My client maintained her declaration initially as part of the adequate cause that she had regular contact with the father to address concerns with the school, and she was the face to the school complaining about their conduct and behavior, but that it was mutual. In Exhibit B to her declaration back in August, she included portions of emails that the school had with both parents identifying concerns and regular reports of behavior. So I don't think it's accurate or appropriate or reflected by any of the evidence that my client excluded him. She was the face of the problem with the school. The two of them were in communication. That's what our assertion is in her declaration. And he was apprised by the school of issues. He indicated at the time he wanted to live with dad. Now he says he doesn't. Unfortunately, it was clear at the time in the filings of both parents that Mason had engaged in animosity towards my client. It is a very glib presentation to suggest that his life with mom is sleeping on the couch and looking at naked pictures of her. That's not accurate. It's not reflective of any of the evidence. My client's declaration regarding the situation, he used her phone. He was able to unlock her phone with Face ID, and looking through her photos, saw a photo. It's something that is very significantly glossed over in the connection from that to sending a naked picture to someone that occurred under father's care and custody. And my client's opinion is identified in her declaration is that something that he effectively tried to sort of sweep under the rug and not acknowledge the concern related to. None of that, unfortunately, I think is really what's controlling. A lot of time spent talking about those past declarations and accusations. My client refuted and denies that she was engaged in any sort of alienation on father. She makes very clear in her declaration, as do the declarations of the family members with whom she resides, that when Mason would come back from visits with his dad, he was very difficult to the point of insubordinate and disrespectful, bordering on misogynist in the way he treated his mother and other women in the household, and they attribute that to father. All that notwithstanding, the GAL's recommendation report was based on observations of the child in crisis, and now all of a sudden he doesn't seem or isn't acting or behaving in any way, shape, or form like he is. I can't say that he isn't. I can't say that he is fine. It is definitely concerning the speed with which that switch was flipped and a 180 is done, and he no longer wants to move or relocate. Mr. Zandy's representation and arguments is that's reflective of the fact that mom engaged in some form of manipulation, and my client is adamant that before she even had the jail report, Mason came home from visit with dad and was adamant he didn't have to listen to her anymore because he was going back home with dad. But that could have only come from dad's house, whether that was seeing dad readying a room for him or something that was said. These things are happening outside of this child. He's reacting emotionally to them. This case doesn't end with whatever decision the court makes. The court found adequate cause. This is just a temporary order. But given the more recent information, my position is that there should not be a change. And as I said, if the court is going to make any change, that more significant visitation be afforded to my client in the interim, whether that's Friday after school to Monday drop off, first, third, and fourth, or what it is, that there should be regular contact for them, because this is just a temporary order at this point, and his current presentation to the GAL is very different than what he had been presenting in the build up to this.
Thank you. Ms. Height, did you want to add anything or clarify anything before I make my ruling?
Just very briefly, Your Honor. Thank you. What I see here is a combination of a little boy who proudly pulls up his pants legs to show me his bruises as if he's about a 6-year-old. And on the other hand, a burdened young man who says what I think is probably the most poignant statement: I can get better. I can get better by myself. And that is very troubling to me, that that's his mindset. I continue to be extremely concerned for his safety, for his mental health. And I stand, having clearly stated to the court his change of statements, I stand firmly on my original report, Your Honor.
I appreciate that. Thank you, Ms. Height. I haven't given this speech in a while, so I'm going to just say it's extremely difficult for the court. The court's getting a snapshot of the lives of people that, Obviously, there's several things happening, several moving parts, a lot of issues. I will take away that I think both parents do care very greatly for this child and want the best for this child. And I appreciate that. Unfortunately, not every child has that. And so I'm glad that that we're in a situation where both parents do care for this young man. I am concerned. I read the report and actually read it more than once because there's some pretty significant and glaring issues, in my opinion, that stood out from this report. I obviously am aware of the adequate cause motion, the things that were agreed upon in that adequate cause motion, the concerns with kind of some of the things that were happening at mom's, the concerns with the behavior at school, and then the, you know, when exchanges were happening and those things. One of the things that I can state, the only person that the child indicates specifically shared information about this case with them was mom. Is that accurate? Could that be the whole truth? No, not necessarily. But he readily admitted to Miss Height that mom on at least 2 occasions, if not more, shared specific information about this case with him. Completely inappropriate. Should not happen, should never happen, and neither party should be doing that. I think a mutual restriction is appropriate and that there should be no involvement of this child in this proceeding. Clearly, multiple interactions between this child and Miss Height. There was one request and one repeated request and one adamantly given request throughout this. And the fact that I do find it interesting that immediately following the filing of this report, there's a change. Am I blaming anyone specifically for that? No, but I do find it somewhat compelling. The thing that most really took me aback was the some of the comments by Ms. Height about the, and this is just a direct quote, I believe the delay of relief for this child could result in unintended and perhaps self-imposed consequences. That this is a cry out for relief, and it is concerning. And I think Ms. Height took a very kind of staunch stance in this case because of her concern for this young child. Frankly, the fact that he was aware that there could be a change is concerning to the court, but the easiest thing is to keep doing what you've always been doing. And especially a child's going to think that. And in a moment of panic, reflection, knowledge of what's coming down the road, I can see a child saying, nope, I want to just do the easier thing because I don't want to disappoint this person, or I don't want to disappoint that person, or I want my friends and need my friends because they maybe have been maybe not the best influences based on some of the school reports, but they may have been consistent for him. And I can understand that. I don't often read reports from a guardian ad litem that touch on such an emotional and kind of desperate need for something to change for a child. And I have reviewed everything in this case. I've heard all the arguments today. Again, I'm getting a snapshot of the lives of these families, and it's difficult to make these decisions. Ms. Height spent a lot more time with these people, investigating this report, speaking with the parties and the child in question. And I absolutely believe that it's appropriate to adopt her recommendations in this case. Do I think it's going to be easy for the parties? Absolutely not. Do I think it's going to be easy for this young man? Absolutely not. I want to stress that both parents need to work together for this child because he is in need of both parents. So there needs to be cooperation moving forward. I don't know, Mr. Zandy, where the child is currently. Is he with?
He's with the mom until I believe this weekend. My suggestion would be
Okay.
maybe hold off on any changes until the weekend, but I'm a little bit reluctant on that, given the amount of influence and communication he's had with mom about these proceedings. I don't want that to be a further trauma to him. So I guess I'd be interested on what the GAL and the court think is best for that. But again, making the transition as smooth as possible is kind of paramount.
I think Tuesday was probably in his head as being kind of the hammer day or the doomsday, however you want to phrase it for him. I think it probably would be appropriate for the transition to happen as it would regularly happen. Miss Height, unless you feel it needs to be more immediate, my inclination would be to have when it's time to go to Dad's house on Friday, then that's when he goes to Dad's house.
I would agree, Your Honor.
Okay. So that's
Is it this weekend, your weekend, Garrett? Just nod.
Yes, it
So
is.
this Friday.
I am concerned for him for the next few days. I don't know.
Is he,
Yes, but I'm just concerned for him.
I completely understand that. And I guess the court doesn't take lightly these types of decisions. They're very difficult to make, and taking all the evidence and information that I've been given, I feel it's the most appropriate at this point in time. As Mr. Baldwin stated, it is a temporary order. And obviously, if other concerns arise, the court's more than willing to take those into consideration as we move forward. But I do think the switch for the weekend is most appropriate. Mr. Baldwin, I don't know if there's a counselor available, or if your client can just maybe notify the school that if there's any counseling that he needs, or a school counselor that may be available for him if there's any issues that arise as we move forward through this week. And I understand. I want him to understand that I heard all of his requests, and unfortunately, this is not his fault. It's not the fault of anybody, but this is the decision the court's making at this point.
So, Your Honor, and I guess I would make sure to clarify, given what he just indicated, that if he asks either parent that all they do is maybe refer him to the GAL, another parent should be talking to him about Your Honor hearing and considering or anything of the sort. I don't want it to accidentally be a situation where my client is alleged to have done something wrong or improper for having expressed that to him. With respect to the visitation, you said that you're following the recommendation. So what is Your Honor setting for the visitation for my client after the transfer? The original recommendation included a cooling off period. I don't know if you're finding that's necessary at this point. So I want to make sure it's clear you're following the recommendation exactly as stated, or what you're doing as far as the visitation for my client.
Mr. Zandy, do you want to weigh in on those two things? If first, do you think it's appropriate to just have the child speak with Miss Height? And Miss Height, is that okay with you if we did something along those lines?
Yes, Your Honor. Would you expect me then to relay to Mason in the broadest of terms what's coming up for him, this change? Is that what you're anticipating?
Well, it sounds like Mr. Baldwin's concerned. He doesn't want to put his client in a situation where she may be, if I am imposing that mutual restriction, then that would kind of prohibit her from discussing what's happening. Obviously, he needs to know that there is going to be a change. He's aware of that. I think he thought that might be today.
Yes, and his question directly to me was, is that going to happen? And my response, of course, as I told you, was, well, we don't know. I'm willing to do that. I'm willing to do that if that needs to be done.
I think there's two people that he trusts at this point, and one of them is Miss Height. It sounds like they have a good relationship with one another. Typically, I would be uncomfortable with the GAL breaking that news, given the circumstances. I am not. The only other person I think that the child, and I'm not suggesting this person, but it just shows kind of the limited scope we have. The only other person that he's really comfortable with at this point was his teacher last year, Miss Johnston. So Miss Johnson is clearly that's not a position for her. I think that leaves Miss Height, or alternatively, both parents can get together and they can meet somewhere for dinner together, and as a joint team, learn to cooperate with one another and tell the child in each other's presence, which again leaves the door open for some chaos, but it also leaves the door open for some healing as well. So I think those would be my suggestions. And again, everybody realizing that there's bigger stakes here than just hurt feelings of themselves, that there's a 12-year-old kid who needs what's best, and hopefully act accordingly and put their own desires over, kind of what's best for Mason. So I'm fine with Miss Height. I'm fine if these parties want to tell the child together. Counseling was not good. There's not a lot of other resources that, Mason is comfortable with. So I think that's probably the best we can do given the circumstances.
And I say, just to clarify too, Your Honor, part of it was Your Honor had indicated, at least generically, that he should be aware that you heard what he had provided to Miss Height and what his thoughts were. And I didn't want either parent to be in a situation where by expressing that they would be in violation of any restraint of discussing what happens in court, even beyond just the relocation is being ordered. So I just wanted sort of to clarify that was, I think, as much as anything, a primary concern as much as the rest. But if Miss Height's comfortable, I don't see any problem with that. I haven't been able to talk to my client. I know it's going to be emotional. And so given what are very strong emotions and feelings about the history with the father, I think that might be more chaotic than good. Although in a perfect world, that would be the best scenario of the two of them to be together. I don't know that that's something that's practical under the current circumstances.
All right, I'm gonna and I appreciate Ms. Height you being willing to kind of take this on. It's a little bit above and beyond what normally would be happening here, but I'm going to defer that to Ms. Height unless the parties communicate by way of Mr. Zanny, Mr. Baldwin, or between themselves and agree to have a conversation with him, the two of them. I agree that would be ideal. I understand there's a lot of history and that may not be feasible at this point, but if that's something that they're willing to do, then I absolutely think that probably would be the best course of action. I otherwise would defer to Ms. Height. So I don't know if the parties want to consider that, and maybe by noon tomorrow, if there can just be a confirmation to the attorneys that they can relay then to Ms. Height that they're willing to do that or they're not willing to do that. So then there's not a tremendous delay in letting him know.
Your Honor, my preference would be to go to the school tomorrow, maybe around noon if possible, and talk with him face to face and have the support. Mr. Fougere, the counselor, would be there. And I'd like to do that sooner rather than later so he doesn't speculate and get worried about, going down some rabbit trails that don't need to be gone down. So if the parties could let me know if I should not go to the school tomorrow around noon, I would appreciate it. If I don't hear from them, I'll just plan to go, if that's all right with Your Honor.
That sounds fair. Is that fair, Mr. Baldwin, Mr. Zanny?
Yes, Your Honor.
All right.
That's fine by me.
Do you want to set a date for presentation, or do you believe agreed orders can be submitted ex parte?
Let's go ahead and set one just to track it. I think it's probably going to be stricken. Let's go 2 or 3 weeks out, and I'll draft those orders.
And I apologize, we got caught in the weeds there, Your Honor. Are you following the recommendation exactly as stated for my client's visitation? Because I don't recall hearing that.
Yes. However, I'm not gonna do the 2-week delay, because essentially that would be a 3-week delay before the next visitation. So it'll change this weekend, and then she'll get the 1st, 3rd, and 5th. So that would be, she'd have her visitation the 3rd. Does that make sense?
So we'll just start the effective date of the parenting plan November.
Okay.
Yeah. Okay.
That makes sense.
Thank you.
And then Mr. Baldwin, does the 7th or the 14th, does one of those work better than the other for presentation?
I don't believe there's any issues. I'm just double checking my calendar. I apologize. The 7th would be my preference.
That's 2 weeks. Does that work, Mr. Zanny?
That's fine.
All right. So we'll set presentation for Tuesday, the 7th, 1:00 p.m. If those are agreed, we can strike that.
I filed my proposed order, and Mr. Anagnostou filed his objections. I would agree with one of his changes, but that's it. And that is number 6, where it says, I had put request for further input from the guardian ad litem is denied. He put reappointment. I listened to the video, and it does say, the court did say reappointment. I don't think it really matters. It's the same effect, but that's really the only, and so I don't know if the court wants to hear argument.
Let's see here. I'm going to make that change. Hold on here. I also just, and I guess Mr. Anagnostou, just so I am aware or, up to speed here, your objections are specifically just to the temporary family law order. That's how I read it. And the other orders you're in agreement with? Or actually the other orders were presented by you, but never mind.
Yeah.
What other orders?
So
To adjust child support?
yes, Your Honor. So what happened was we had competing motions come before you, and we have trials set for the week of November 6th. So that's coming right up. And we set over the child support issues because we don't have tax returns from Ms. Kudo's client yet. So that got set over to trial. And we requested that her motion be set over to trial. It was my understanding we were simply talking about the October visit to make sure that Mr. Hoffman got the October visit, and then we would be in trial in November. Ms. Kudo has written her order as permanent changes, and these are issues that are set for trial. November 6th of next month, just a couple of weeks. That about the travel. She indicates in here, and it wasn't discussed, that if the trial date is continued, the child may continue to fly unaccompanied. That's an issue for trial. And in the future, if that's a big issue, the unaccompanied, Your Honor has seen declarations regarding that. And that, for all visits scheduled in accordance with the current parenting plan, the current parenting plan requires 30 days notice that Mr. Hoffman provides my client. Ms. Kudo is now, indicating in this order that it gets cut down to 10 days. And like I said, we were just concerned about the October visit occurring, and then we're going to be in trial with regards to these issues. But she's indicated that permanent changes, in particular, number one, Your Honor never indicated provision number one, that the child may continue to fly unaccompanied wherever the respondent lives. I mean, that's a current issue now. He was living in Arizona, and now he's moved to Eastern Washington, to the Washington, D.C. area. This is a substantial impact on the child in these visits. He just had one that we scheduled in October, where he had to miss at least a partial day of school, and he came back extremely tired.
Yeah, and Your Honor, I'm going to object to counsel raising. I have an objection to counsel raising new issues. We're here on a presentation. I've got different information, and so I would just ask that he keep his comments strictly to the order.
Okay, but so the order and motion to adjust child support, that's not, I have proposed orders that the clerk gave me. I can just set those aside. Is that correct? Because that's been deferred to trial.
We would agree
Yes,
that was
that's
going to be set
correct.
to trial, correct?
Okay,
So the only thing before the court is the proposed order that I filed in regards to your ruling back. I think it was when we were before the court, and I took it directly. I actually got a copy of the court's ruling, and it was taken directly from the court's ruling. So there was no attempt to hoodwink the court. It was as close to Your Honor's statements as possible. And the reason why this is so crucial that this order be very specific is in the past, Mr. Anagnosti's client has taken the orders and completely revised them, not followed them, and we have to have very specific language. Otherwise, it doesn't happen. So this, and I can even tell the court exactly where you made these rulings because I have a copy of the ruling.
I did review the 9/26/23 hearing. I do have a copy of the minutes in front of me and the notes that I made on that, or for that hearing. I did rule that the child can continue to fly as an unaccompanied minor, that the ticket should be purchased and given and notice given at least a week prior to any travel, and that the visit shall occur monthly as previously ordered. So as far as the not making a determination moving forward, I would, frankly, I think we all would be remiss to not address this as a continued issue if for some reason the case doesn't proceed to trial in 2 weeks from now. Hopefully it will. I don't frankly know what's on for readiness that week. It is civil priority week, so hopefully there will be space for this to move forward. So I, as to the objections for number 4, objection number 4, I did make that change. So it now states petitioner's request to reappoint the guardian ad litem to conduct additional investigation is denied. As to 14.4, visits may occur as frequently as allowed by the current parenting plan, where it indicates the court did not make that order. I would disagree. I did say that the current order is where we're at, and visitations shall occur as previously ordered. So I'm going to deny the objection to number 3. Which is in reference to 14.4. Then objection for paragraph 14.2, which is tickets should be purchased and notice given as timely as possible, but no later than 1 week prior to the travel date. That was, my recollection was that was specifically for October.
Right.
So I think there is in the plan, my recollection, the plan affords a longer time period for as we're moving forward. I think that would stay status quo, but for the October travel, the 1 week was appropriate. So what I'm going to do on 14.2 is just at the end of that sentence, say for October 2023.
So it doesn't, and Your Honor, the attempt was not to change the notice. My client knows that there's a 30-day notice. It was just for purposes of the purchase of the airline tickets. And I don't think there's a 30-day notice requirement for that. I believe that it's, but we can refer to the order because.
And I would agree with you on that. So,
okay.
But for this, my recollection was kind of October based on the filing of the motion. October was sort of on hold. And so that was going to happen kind of on a truncated time frame. So,
okay.
But the order, I know that there's an extended notification for, hey, it's going to be these dates.
Right.
The information regarding the exact time and flight information, I think is less than that. So
mm-hmm.
I'm going to just.
My attempt, Your Honor, it was more looking at tickets. I was not attempting to change the 30-day notice because we've given our notices. It's just the tickets purchased themselves. I'll just instruct my client to follow the order.
Your Honor, this is Corey Hoffman. May I address the court?
No. You have an attorney. If there's a concern, you can send a message to Ms. Cotto unless she's comfortable with you discussing anything in open court.
Corey, I'd rather have you text me if you can.
Okay. And then as to objection number 1, 14.1, 14.3, proposed language is a fundamental change. Court did not order this change. Specifically ruled current scheduled visit was to occur, but the court did not change the current order, which is the subject of trial set week of November 7th. So, and just, so number 1 is may continue to fly unaccompanied regardless of where respondent lives. And number 3 is if November 2023 trial date is continued, the child may continue to fly unaccompanied for visits scheduled in accordance with current parenting plan as scheduled in advance. Any further comments on that, Mr. Anagnostou?
No, it's just that I think that's consistent. We were talking about October and into the future. If this is an issue, if we don't go to trial, then we bring it back by a motion if it comes up.
No, I'm going to adopt those. This is not, Miss Hoffman gets to bring this every single month because she doesn't like it. This is unfortunately the situation that these parents are in. There's an order that's in place that addresses this and allows for him to fly as an accompanied minor. What I am going to do is I'm going to, on 14.1, I'm going to strike the last portion regardless of where respondent lives. I think it's fair if Mr. Hoffman is relocated to Korea, then obviously it would be there's a discussion that needs to happen, or Hawaii or wherever. I think that if there's a major change in location, I think that's fair to address. We know where he is now. All of the submitted testimony basically is that this is where they're going to be based on his. I'm sorry if I can't remember if it's wife or fiance's current station. So that this is kind of where they're expecting to be for the foreseeable future.
Would the courts consider it in the continental United States?
Your Honor, if he moves, we need to have a discussion, and if we can't come to an agreement, bring it to court.
Yeah, I'm gonna just child may continue to fly as an unaccompanied minor, period. And then number 3, if the November 2023 trial date is continued, the child may continue to fly as an accompanied minor for all visits scheduled in accordance with the current parenting plan. I think that is appropriate.
Okay, and one thing I want just to note for the record is that it's never been 30 days for notice in regards to ticket purchase. That was just 30 days for notice of requesting visits. And I believe it was only 7 days.
I don't know if I agree with that, Your Honor, but.
Well, right. Mr. Okay.
Are you in Odyssey looking at that, Ms. Cotto? Or are you looking at the plan somewhere else? And what is the date?
Yeah, I was looking at the plan. I was looking at the plan in my file.
Do you know when that was filed, just so I can try to address that really quickly?
If the court will give me 2 seconds. I believe it was February of,
2018.
that's correct. And that was the last parenting plan. And I don't recall that there was a notice provision for flights at all. I think it was just notice provisions for here's the visits. Because I don't recall them ever having a provision in there that says that my client had to give her 7 days or a week's notice or 10 days notice in regards to the purchase of the tickets. I think the parties did the best they could as far as getting.
It's on page 5 of that order, Your Honor. Notice provisions. Father shall provide 30 days advance written notice for summer visitations with the child by text and email.
It doesn't address the notice provision for purchase of tickets.
I guess with the parties on page 4, so there's starting on page 3, there's a school set schedule, and it has cash and then a couple paragraphs, and it has Kyra and a few more paragraphs, and then it has notice provision. And it says father shall give mother 10 days advance written notice prior to visitation. Mother shall acknowledge receipt within 48 hours. Father's visitation shall occur. Mother shall give father 30 days advance written notice of her dedicated weekend. Father may not schedule his time over mother's. To me, it's hard to tell if that applies to both children because it does talk about going both ways.
The other child is already aged out, so we're only talking cash.
I understand that, but I guess I don't know if that notice provision on page 4 of the parenting plan applies to both Kyra and Cash based on how it's written. It does appear to address both when mother's doing her visitation and when father's doing his visitation, which would, in my reading of it, see that it applies to both, which is 10 days advance notice prior to visitation.
I think that was just the advance notice for the visitation. It has nothing to do with the purchase of the tickets.
Yeah, the tickets I think is, I don't want to say less of a concern because obviously the parties would need to have notice of when they needed to be somewhere with the child. But the long and the short of it is this has been already happening for 5 years. So, and they've been making it work. And to now all of a sudden claim that they don't know what's going on or they don't know how it works is a little disingenuous, frankly. So I am going to just leave the wording as it is in the order, and the parties should follow the parenting plan. And we are set for, looks like, excuse me, we are set for readiness the 31st at 11:30 and trial week of the 6th. So we will see you all then, and I will get this order entered.
Good afternoon, Your Honor.
This afternoon.
Amanda Holder here representing Ms. Maxton.
All right, we have a motion for adequate cause, a show cause, contempt, and so a couple different things happening. This is all after a final parenting plan was entered in June of this year. So I've reviewed everything. Let me just make sure nobody filed anything late. Okay. There's a few things that I haven't reviewed that are just coming in. So it does look like the most recent declaration was from the 18th. I did review that. So I am ready for whatever argument parties wish to give.
I think that the issues kind of are commingled, so I'm fine with Ms. Holder presenting first. I would like to memorialize an objection that I did present within my client's responsive materials, just to the consideration of the submission filed within the underlying declaration. It was about 40 or 50 pages long. The first 14 pages of that submission contain about 14 pages of single-spaced notes, alleged to be visitation notes from mother. Those are not made under penalty of perjury. They go far outside of the page limits provided by Rule 88. So I am objecting to the consideration that the court does not consider that for the purposes of today.
So hold on, that's index number 133 in Odyssey, and has also some text messages attached to it. Okay.
Yes, I can't tell, but I don't have the numbers associated, but it was right. It looks on Odyssey right before her underlying declaration.
I have it filed September 26th and was signed, the cover sheet was signed by Ms. Holder on the 25th of September. There's,
I'm actually-
sounds like, is that the same thing? Says pick up and drop off notes since
Yes.
final parenting plan, text messages, and school calendar.
Yes.
Okay, Ms. Holder?
Yes, Your Honor, I understand the objection, and I would agree that it does go outside the page limits and it's not being submitted for the purpose of a declaration or a substitute of one, more that it is evidence that Ms. Masden takes copious notes before and after each drop off, just as a matter of veracity. As to the included text messages, I do not believe that would go over the limit and should be considered part of the submission.
And I guess, Ms. Gilmore, just to clarify, was your concern more with the notes and than the text messages? Okay. All right. When I started reviewing these, I noticed that myself, and to be fair to all the parties, I did not review the 14 pages of notes, the pickup drop off notes. So I did not review those.
Thank you.
All right, Ms. Holder, go ahead.
Your Honor, we are asking for a modification to the parenting plan. We believe there is adequate cause. The most recent time we were in court was on August 15th for a contempt hearing. And that was because Mr. Mazza was drinking and got into a physical altercation on July 4th. He was held in contempt, and that order was signed on the 21st of August. The reason that Ms. Masden wants to modify the parenting plan when one was just put into place is because the one that was put into place in June of this past year was an agreed parenting plan that the parties worked on between themselves that came up with a reasonable approach to co-parenting their child. And it was very clear after a restriction on drinking was put into that parenting plan that Mr. Mazza did agree to, that he did not intend to abide by the parenting plan. And so Ms. Masden filed for contempt. And I would note that this case has been going on since 2018, and that was the first time she ever filed for contempt. Even though I believe that there are plenty of other times she could have filed, she never did. So she filed for contempt, and she immediately wanted to modify the parenting plan due to Mr. Mazza's unchanged behavior. The reason we believe there's adequate cause is, one, he was found in contempt for drinking and fighting on the 4th of July. He doesn't use proper restraints in his truck. He sometimes will put his son in the front seat without a car seat. There is
I'm just going to voice the objection. There's no personal knowledge relating to this. I understand that likely won't be sustained, but I don't think that any of these comments are made with any sort of personal knowledge, as she's not subject to my client driving around with a child.
All right, noted. Go ahead, Ms. Holder.
There is an open CPS investigation that Mr. Mazza left 2 of his children, including the child he shares with my client, left the children in the vehicle while he went shopping in Target. There's the issue of missing school. So far, Chance, the child, has missed 3 days of school so far during this school year. Each one of those dates that he has missed has been with Mr. Mazza. That's average a missed school day for each visit that Mr. Mazza has. My client, this is not going to be on the record, and I'm sure it'll draw an objection, but my client just got a call from the school this morning that Chance, again, while he is with Mr. Mazza, has missed school.
I'll object to that. She's obviously preparing for the objection. I don't even know if it needs to be stated.
And there was no way to put that into the record, as it just happened this morning. There's also the issue of improper medication for the child. Chance is diagnosed ADHD and he has autism. So in the morning he takes ADHD medication, in the evening he takes impulse control medication. Sometimes Mr. Mazza doesn't administer the medication. Sometimes he just forgets. There's the issue of the junk food. Mr. Mazza makes it a habit to take Chance to Taco Bell, fast food restaurants. This is a huge issue because Chance is pre-diabetic and he has, the doctor is concerned about the obesity. And as a result of the obesity is pre-diabetic, which is why it is extremely important to not necessarily follow a strict diet, but to make sure that it is a healthy diet. And also when it comes to the junk food, It's not just fast food. In the declaration my client mentioned, when she went into Mr. Maz's home, she saw a mini fridge in the child's room filled with Dr. Pepper. So this is an issue that Mr. Maza clearly doesn't take seriously as his child's health, whether it be the mental health through the medication administration, or whether it be through the dietary health, giving him junk food and high sugar foods. When it comes to Chance reading the nutrition labels on the back of things, as is stated in one of the declarations put forward by Mr. Maza, that is because my client reads the nutrition labels and Chance is impressionable and picks up on that and also checks the nutrition labels. It's not because his mother makes him do it, it's because he sees his mother doing it. This is a case where it's clearly Mr. Maza wants to be the fun parent. And Chance just doesn't want to go home with him, go to his house, which leads into the contempt issue. And the reason that Chance doesn't particularly want to be at his father's home is due to broken promises. It would be one thing if Mr. Maza's bribes were consistent and followed through with, to say, oh, if you come here, we're going to do all these fun things. But when you break a promise to a child remembers. And that's one of the reasons that Chance doesn't want to go home with his dad. There's a lack of attention when Chance is there. There are other children in the home, and Chance, being autistic, he does require a lot of one-on-one attention. As far as the contempt goes, as I mentioned, this is the first time in 5 years of an ongoing case that any contempt motion has been filed. My client won that contempt motion back in August. 4 days later, Mr. Maza then came forward with his own contempt motion. This is clearly a retaliatory motion and it's frivolous. This case has been contentious really since about 2020, when Chance went back into his dad's custody after a 4-month emergency custody. That placed him in his mother's care. When he came back, he started having some behavioral issues. This has now escalated, and really starting in November of this past year, Chance has started refusing to go with his dad. Looking at the file, you can see declaration after declaration from many people stating this. That's a fact. It's happened. And this is the first time that Ms. Masden has filed a contempt motion. She won the contempt motion. And then 4 days later, Mr. Maza comes forward with his own version of a contempt and says that it's warranted, and clearly it's not. This is I don't see how this can be seen as anything but retaliatory. I think in this case there is a lot of contention between the parties. I think that's pretty evident. What's happened here is a child has been caught in the middle of it, and this isn't a case about my client thinking Mr. Maza is a bad guy. This is him wanting to be a dad, and if he wants to be a dad, he needs to be responsible. He needs to be responsible in that he can't always be the fun parent. Sometimes he's going to have to make sure the child eats broccoli as opposed to Taco Bell. He's going to have to make sure the child gets his medication and not forget it. He's going to have to make sure that he goes to school every day, unless there's a reason why, like sickness. That would explain being taken out of school. But to miss a day every time Mr. Maza has custody is it's not reasonable to allow parents to do that and to say that they are behaving responsibly. So that is why we believe that there's adequate cause in this case, and we also do not believe that this contempt motion should be upheld.
Right. Thank you, Ms. Gilmore.
Thank you. Respondent PC Maza. This is before the court on both my client's motion for contempt and motion for adequate cause. I'll first address the modification. Looking to the history of the case, a final parenting plan was entered on June 26, 2023, less than 4 months ago. This agreed order provides no RCW 26-09191 factors against either parent. When mother began withholding the child, my client brought a motion for contempt to enforce this order on August 25th, and she was personally served on September 13th. Just looking to this argument of retaliation, based on I obviously wasn't in on the case at the time, but the motion was filed and served on my client in July. So I'm confused by the assertion that 6 weeks later he's retaliating for a motion that he frankly wasn't even before the court on, because he couldn't continue to sit on the docket. And we believe in retaliation of enforcing another order, mother filed a petition for modification, which is the second within 4 months. It's also important that this was before the court in 2020 on mother's petition for modification that was denied, and the court found no adequate cause. As the court is aware, the standard for a major modification is high, and the moving party must prove that there's been a substantial change of circumstances for the non-moving party or the child since the last final order was entered. I frankly have never seen such a thin request for adequate cause that's supported by zero personal knowledge or facts. I understand that there's some leeway given for hearsay in family law cases. However, mother presents generalized allegations, again, with no personal knowledge or even alleged hearsay by third parties. Again, mother makes copy and paste arguments, generic arguments against my clients that, again, are identical to what she submitted in the petition in June, and frankly, her petition in 2020. I ask the court to really question the veracity of her statements, as she's repeatedly pled under penalty of perjury that my client abuses substances, is domestically violent, and going on, and then turns around and agrees with counsel to enter an order with no limiting factors whatsoever. There's absolutely been no change on the part of my client or the child, but for mother refusing to comply with the order despite repeatedly being admonished by this court, as well as involving this child in conflict. So he feels like he is put in the middle about going to visitation. This is the same individual that when my client contacted law enforcement to facilitate exchange, she notified law enforcement that her attorney advised her not to comply with the court's order in support of a modification. Looking to the specific allegations by mother, there was no CPS investigation, and there's surely no open CPS investigation regarding my client allegedly keeping the child in the car at Target. Again, this is an allegation that's coming out of thin air. You have no statements from third parties. I have no understanding where mother is even coming up with this. She then contacts my client and he adamantly refutes that he has ever kept the child in the car. Mother's abuse of conflict is truly shown within the CPS material that I've submitted within our responsive pleadings. Mother abused her position as an employee within a mental health facility and lied to a mandatory reporter, I believe likely a friend, that my client's child from another relationship had a black eye. This child is prohibited from having any contact with mother in this case because of her abusive conflict, and mother hasn't seen this child in many years. My client, again, is adamantly denying any sort of abuse whatsoever, and mother is willing to slander him and lie to state officials to continue to harass my client. The CPS report really speaks for itself. There's no abuse going on in my client's home. The child not of this action didn't have a black eye, and the case was closed. There's simply no open investigations regarding anything involving my client. Mother similarly makes very weak claims regarding my client's home or the food that she feeds my client feeds the child. Again, I'm asking for personal knowledge. She's never coming to my client's home. She doesn't know what he feeds him, and she similarly doesn't know anything to support he's not providing medication. My client pleads under penalty of perjury that the child is happy and healthy and he feeds him healthy foods and he's providing him medication during his residential time. There is nothing to the contrary that supports the allegations. Mother again supports her claim by a generalized allegation that my client doesn't take the child to school. But she fails to note that since the June 2023 parenting plan was entered, my client only started to have overnight visitation simultaneously to her filing the petition. So by the time that she brought this case, he had one overnight, and we provide text message communications where he's providing notice to mother that you brought the child to visitation sick, we're now both sick, and pursuant to the school policies, I'm not going to be able to provide the child to the school. That is the isolated incident that she is referencing, but failing to acknowledge the timeline of this case. Further, as acknowledged within the order that was submitted 4 months ago, my client does not have substance abuse issues. And again, this is acknowledged within the order that was prepared by petitioner's counsel. He's never been convicted of a DUI. He adamantly denies drinking or physically fighting in front of the child in July, and he would have responded and asked for a set-over, but for the fact that he had sat on the docket for 2 hours and he had to go back to work. I acknowledge the fact that he should have responded as a pro se litigant. Again, I wasn't in on the case. But just because he failed to respond doesn't mean that the facts that she presented are true. They were made without personal knowledge. My client did not admit to drinking or drinking in front of the child in the text messages from July. And I think more importantly, look to this timeline of this case. This allegation happened allegedly on July 4th. It's now the end of October and she's bringing a petition for modification only in response to my client's motion for contempt. There's, again, simply no substance abuse issues here. As by looking to the contempt, mother is refusing to exchange the child. My client provides detailed information regarding the exchange in August. I think that, again, text messages speak for themselves. It's frankly not attractive in the sense that she's taunting my client. She's saying that as a picking up parent, he's responsible for coming into her home, dressing the child and ripping him out of her home. I mean, that is simply not the standard here. The child should be ready for exchange, and she should be supporting the child and encouraging the child to go to have visitation with his father as it's in his best interest. My client had personally heard mother speak to this young child, offering to do fun activities, go bowling and the like, if you don't go to visitation with your dad. When my client did actually go into her residence and attempt to facilitate the exchange, the mother was audibly laughing and thinking it was funny. The child has frankly never locked himself into any sort of room throughout the pendency of this case, and mother had the ability to unlock the door, but refused to do so. My client then left the residence, contacted law enforcement, and by the time that law enforcement and my client had gone back to the home, mother and child are getting into the vehicle to, again, go to said fun activity. Mother then became infuriated because my client was actually enforcing the parenting plan and started screaming obscenities in front of the child to my client. Ultimately, at the end of the day, my client is simply trying to have a relationship with his child. He's not an inferior parent to mother just because she thinks so. I am concerned that she'll continue to violate court's orders and continue to bring frivolous litigation, given the fact that we've had 3 petitions for modification within a 3-year period. That's just simply absurd. So I do ask the courts to deny the motion for adequate cause. I ask the court grant the motion for contempt, and I'm happy to present an attorney's fee affidavit, but this was expensive and costly to present. There was a lot of materials. I've gone over the $2,500 retainer, so we are asking for at least $2,500 in fees for both the contempt and, frankly, for the petition for adequate cause, which is not supported.
All right. I've reviewed all of this, all the submissions, and I've heard the argument.
May I have one quick rebuttal?
No, I'm denying the motion for contempt. I'm denying the motion for adequate cause. These people need to get their act together and realize they're co-parenting a child with special needs. I can't make that more clear. This order was just entered. You need to figure it out. Both parents want to be actively participating in this life of the child. It needs to be allowed to happen. There is not adequate cause. There just isn't. And there's no, I agree that mom should help facilitate the child being prepared for visitations. This isn't a teenager, an older teenager that knows exactly what needs to happen and when it needs to happen. But this behavior is pretty abhorrent by both parents. But we need to have an opportunity for this parenting plan to work. Mr. Mazza was not represented when it was entered. Ms. Madsen had every opportunity to take advantage of that, frankly. And it was an agreed parenting plan from 3 months ago. This is frankly frustrating. And to say that Mr. Mazza's contempt was retaliation only to have an adequate cause motion filed 3 or 4 weeks after that, I mean, I think it's kind of disingenuous, to be very frank, but I'm going to deny the motion for adequate cause. I'm denying the contempt. The parties need to work together to follow the parenting plan. Ms. Madsen needs to have the child ready for transfers when it's dad's opportunity to have the child. Mr. Mazza needs to have the child ready to be transferred back to mom when when he's to be returned to mom. I am denying, and I had 2 orders. Ms. Gilmore, I had 2 orders that were submitted by your client. They were identical for the contempt hearing. I don't know if you filed a supplemental one. So one of them is going to the shred pile. The other one I'm just going to deny. Additionally, he asked for makeup time. I don't think that's appropriate either. So I'm going to just deny the order for contempt. So I'm not making a finding of contempt on Miss Madsen, but I also do not think there's adequate cause. These parents just need to figure out how to work together. Frankly, some of the allegations, comments, that they're doing whatever they can to make it more difficult on each other. And frankly, that makes it more difficult for this child. I think they need to reassess what they're doing. And that's the final ruling for this matter for today. So both requests are denied. I'm not making a finding of any attorney's fees at this point.
Do we want the theory to set a presentation? It should be pretty generic, but Ms. Holder, do you plan on?
I don't think I have any upcoming closed docket. So whatever works for the parties.
Next week's fine, just because I think it's a pretty basic order, but ultimately, Ms. Holder, if you're not available to draft, then I'm happy 2 weeks is fine too.
If you'd like to draft the order, that will be fine.
Sorry, I didn't hear what you said. You want me to draft the order? I can do that.
Yes, if you would. Thank you.
I can do that.
And is 1 week enough for that, Ms. Gilmore?
Yes, I can do that today.
Does that work for you, Ms. Holder? Here on adequate cause motion?
Correct. Along with a request for temporary orders, Your Honor.
Yes. And let me just make sure. We've had a couple late filings. Looks like the last.
I just wanted to put this on the record. I'm withdrawing my objections to the late filing. Mr. Zandy had actually reached out to me and we agreed, and then I forgot that we agreed. So I am striking that objection. to the late filing of the reply deck.
Okay, I didn't see an objection. So
Okay.
if that was filed, it didn't make it into Odyssey. So,
Okay.
but I'm assuming that we're all talking about the 1020 filing because I don't have anything post 1020 in the file.
Yes, I believe so. Correct.
Okay, and it was a reply declaration of Rebecca Swanson that was dated October 20th.
Correct.
That's correct.
Okay, all right. Whenever you're ready.
And thank you, Your Honors. The court's aware I do represent the petitioner and moving party to the motion and petition in front of you to modify or at least take a good look at the existing parenting plan, namely Rebecca Swanson. I think what's happened largely speaks for itself. Now, these parties were recently in on a modification on an adequate cause. The hearing court at that point denied it. Looking back, it was in quite a bit of flux for a long period of time. But regardless of that, we're now here on new issues that are certainly substantial, certainly a change in circumstance, and certainly worth taking a look at this based on the potential impact to this 7-year-old child. Bit of history on this. This is a parenting plan that was entered by the parties on a pro se basis by agreement. They did the best they could, and there is very significant holes in the existing parenting plan. Now, so much as the school schedule is omitted. Now, there is no school schedule once the child reaches the age of kindergarten. These parties have been forced to essentially kind of patch this together, but as far as enforceability and construct of the plan, there is none. So that's first and foremost. Child was very young when the parenting plan was entered back in 2017. She is now 7 years old and involved in school. So that's clearly one of the changes in circumstances. The existing parenting plan doesn't contemplate that. More readily available, and I think even clear example of the change in circumstance is unfortunately the issue that occurred back on September 6th, or about a month and a half ago, in which there was a very significant episode at the father's home in which he was intoxicated or impaired, according to the police reports which we have filed for you. Started following his wife and small child, not the child at issue in this case, but born from another relationship, following them around the house in a threatening manner, breaking various items, again in an altered emotional state. Wife leaves. Wife comes back the next day at 11 a.m. Nothing has changed. Mr. Barnes continues to be intoxicated and continues to be in a very, I would say, irate state of mind. Again, doing largely the same things that precipitated her leaving the night prior. Mr. Barnes' father calls police, and again, that information is contained as part of the pleadings for you. Police arrive due to the call, and Mr. Barnes essentially barricades himself inside the home in Silver Lake and refuses to come out despite officers' commands. Search warrant is procured by the responding officers. The SWAT team comes. Mr. Barnes is essentially at the door yelling obscenities and telling the officers to essentially F off and lick his genitals, I believe is what is in the police report. And tear gas is eventually used, and they finally get him out. During the course of this, he's throwing property outside the house. We've attached photos of you of him destroying doors, throwing food outside at officers, throwing home furnishings outside, even going so far as to thrashing himself across an air conditioning unit, causing lacerations throughout his face. In addition to the police reports you have in the search warrant affidavit, you also have statements from his now wife, Ms. Fias, which again collaborates a lot of this information, which has been presented, expressing concern about his state of mind, the use of alcohol, and the incidents which occurred a little over a month ago. There's adequate cause there. Now, my client obviously concerned about this. I think it's important if you review, and this again comes down to the one party's ability to be forthright and honest for this court, tell the truth and not misstate facts. But again, it bears mentioning, if we go back a year ago to when the initial adequate cause motion was filed, Mr. Barnes was very straightforward in his denial of those allegations, saying that not only does he not consume alcohol or drugs, but he goes so far as to say, I don't even consume caffeine. Again, that was less than a year ago. And here we have the information presented to you that shows that was clearly not where he was, and that was clearly misstated to the point of being extremely fabricated. Also have the statements from his wife back then, again, confirming a lot of his statements, which is not surprising. And we certainly know where her allegiances lie. But now in contrast to that, you have the statement that she made to arresting officers, which contradicts a large amount of what she stated in her past declarations. I was somewhat surprised when we did get Mr. Barnes's responsive pleadings, in which he basically, if I'm reading this correctly, alleges my client is conspiring against him to change the parenting plan. And that shows to me and specifically states, this leads me to believe these recent allegations are part of an agenda to remedy the parenting plan. He doesn't take any accountability or responsibility. He provides you with a drug test and alcohol screen from nearly 2 weeks after the incident occurred, and a self-reported assessment that says, yep, see, I told you I'm fine. I'm not consuming alcohol. But the reality of this situation, again, shows something starkly different. The old words from people on his side, and again, that have come to bat for him in the past, states that he was emotional at the time, that he had some kind of emotional breakdown. But we don't know where that lies. Other information states that he has been in some kind of depressive state. We provided you information from the past in which his own mother years ago then talks about his substance abuse history. All of this information needs to be gleaned and presented to a GAL for review of this. There is some very significant concerns about what's happening in Dad's house, what the magnitude of these issues are, because clearly they are not being treated in an effective manner. I think lastly, it speaks volumes when the parties, again, trying to, in a spirit of co-parenting, attempt to arrange a time to meet with the child's new teacher and have essentially a parent-teacher conference at the onset of the school year. Mr. Barnes says, well, let's schedule it for a day when I'm available at 11 o'clock or 9 o'clock, first thing in the morning. My client does that. Mr. Barnes is a no-show and then reports the fact, well, I slept in, I had to work the night before. When the reality is, this is on the heels of him being arrested for barricading himself inside the home, destroying property in a drunken stupor. So that's kind of where we are. And we absolutely believe that this needs to be changed. And again, the question begs, what are we changing? Because there's no enforceable parenting plan. There's no provisions related to the school schedule. We're asking you remedy that today. We're asking you proceed with caution until we have input on mental health evaluations and alcohol evaluations, and these criminal charges can gain some traction. This was a very significant episode. I think it downplays it significantly when Mr. Barnes alleges and says, well, I essentially had a bad day. Although I certainly had my share of bad days. Knock on wood, the SWAT team has never had to come and use tear gas to get me removed from a facility. It goes beyond having a bad day. This is a crisis of sorts. So we are asking that you adopt our parenting plan or our version of visitation. This child loves her dad. And there's no doubt Mr. Barnes loves his child. But we do believe that we exercise with a little bit of caution given the circumstances and the recent events from last month. We're asking that visitations be professionally supervised pending GAL involvement and report back to this court. My suggestion is we set this 6 to 8 weeks out, or at least before the Christmas holiday, so that a GAL can report back and see how far these issues lie. In the meantime, we're asking Mr. Barnes to get a complete mental health evaluation with input from my client, as well as substance abuse evaluation with input from my client. Again, appoint the GAL. Pending that, I think having a safety net of supervised visitation probably makes the most amount of sense. You can see between the parties that there is distrust between both of them. I think the only way to kind of soothe that or make that reasonable would be to appoint some kind of professional supervising facility, such as Reconnecting Families, or some kind of agreed upon third party facilitator that can ensure the health and safety of this 7-year-old little girl.
And just one quick question, Mr. Zandy, and I apologize if it's in your pleadings and I did not see it. The adequate cause was last, I think, November. When you made mention of it, I did review the judge's ruling at that point in time, and I think there was even a motion for reconsideration, and I reviewed that as well. Your position is a matter of law because the parenting plan does not address what happens when the child is school age, that there's adequate cause?
I think that's one of the various bases we have. I think if you really want to get down to it, you could probably pinpoint 4 or 5 different bases of adequate cause. I would certainly think that's one of them. The arguments I made at the last hearing last year related to that was if there's a change in circumstance, and the law doesn't define what a change in circumstance is, outside of being either to the non-moving party or the child, that's the basis for adequate cause and to review the parenting plan. In this instance, because there was no school age schedule specified, the fact that the child has now commenced school, that would be a change in circumstance to the child, which would warrant the adequate cause finding. Judge Scudder disagreed with me, and clearly I respect his opinion, but I do think that from an area of law, that was, I don't necessarily agree with his analysis.
Okay, I appreciate that. Ms. Petrie, good afternoon, whenever you're ready.
Good afternoon, Your Honor. To start out, I would like to state that I do believe there is adequate cause for a minor modification. The parties do need a school year schedule. I believe the holiday schedule needs to be modified a bit or adjusted, and there's some holes that need to be cleaned up. I will agree with that. What I don't agree to, well, let me make some notes for the record. Mother's request for protection order has been dropped. On the basis that there is a lack of evidence. There is no criminal action pending. All criminal charges were dropped on 9/11. All drug tests, including a hair follicle test, have come back clean. And the fact remains that my client was in the privacy of his own home. He only broke his own stuff. And he did talk about it. He did acknowledge it. It's called a relapse. It doesn't make the statements that he made last year false. He even talked about it that this is a relapse. That's what this is called when you're in recovery. And he has taken steps to address this relapse and get back on track. He is involved in therapy and he is addressing these issues. That being said, and based on that fact, we need to go back to what things have been historically. Like I said, while I do agree with a adequate cause finding for a minor modification, I do not agree with adequate cause for a major modification. The fact is that the parties have been operating on a 50-50 week on week off basis for 6 years. That's the status quo, and there's no reason that should not continue. There is no evidence that my client poses any danger to or risk of harm to the child. I do apologize. On father's side, it should be noted that mother's unilateral decisions and actions regarding medical care and her resistance to share information with my client about his daughter are also things that the court needs to be concerned about and look into. She speaks negatively about my client with the child and allows others to also say bad things about as well. She brought forth these allegations in bad faith. The drug test results, including the hair follicle test, completely contradict her claims. Last year, when the court considered her motion for adequate cause, my client was able to provide documentation proving that her allegations were false. The judge then even acknowledged that mom is not afraid to make fair and unsupported allegations. For mom, it's all about control. Any misstep taken by my client is brought back before the court in an effort to gain custody and control over the child. Mom is not supportive of dad's relationship with the minor child, and there are other issues, but a major modification that actually affects my client's visitation, no, there's no grounds for that here, Your Honor. There's no risk, there's no threat of harm. My client never threatened mother or the child. There's no risk. So we are asking that the court maintain the status quo with 50-50 week on week off parenting time and adequate cause as to a minor modification in order to put in place a school aged schedule.
And Ms. Petrie, they're requesting a GAL. I'm assuming you would not be inclined to agree to that.
If mom wants to pay for the GAL, they can go ahead and my client will, I'll recommend to my client that he cooperate. Absolutely.
Okay, thank you. Mr. Zanni.
And again, the law is pretty clear on this. I mean, at this point, we don't have a parenting schedule, and paramount to that, and probably more importantly, is there's been a very substantial change to Mr. Barnes. And that was, again, a month ago after he had an alcohol-induced mental health crisis where the SWAT team was called. Night before that, thankfully, Adeline was not there, but his other child, who I believe is 2 or 3 years old, Skylar, was present in the home, watching him act this way and essentially follow his wife, Skylar's mother, around the home, breaking various items. So to suggest that he's not a danger to children or my client, again, I think is disingenuous at best and just not supported by Ms. Fias's own comments, that's the current wife, to the police, or Mr. Barnes's own father's comments to dispatch when he called this case in. So yeah, I mean, this is certainly grounds for a major mod. This is certainly well beyond what we sometimes see, unfortunately, and there is certainly potential for harm, and there certainly is a pose for risk to this 7-year-old child who, again, has been exposed to this in the past, as we're confident a GAL will probably find. So that's why that is important. I would suggest as well that a GAL being appointed is appropriate. I would also suggest that we're in this position because of the incident, which again was alcohol induced back in September, after Mr. Barnes swore under the penalty of perjury to this court that he doesn't drink. He doesn't consume as much as caffeine, let alone alcohol, which clearly was not truthful. So we are asking that he contribute, or if not pay, the entire freight of the GAL appointment, as well as contribute towards some of my client's attorney's fees and costs, because again, we're here because of his actions, and that is certainly appropriate. And we are asking for the adequate cause finding, for a major modification. And again, that is certainly supported by the facts and the law, given the circumstances of what has occurred over the course of the past month.
All right, just give me one moment here.
May I make one final?
Your Honor, have the opportunity to review the police report along with the pictures that we provided in the initial motion.
I did.
Okay.
Yeah, yes, Ms. Petrie, go ahead.
Thank you, Your Honor. Your Honor. Again, he was sober and had 11 years of sobriety under his belt, I think even longer. It's called a relapse, and those happen sometimes. And no, we don't like to see it, but we also don't punish it when they also turn around and try to make the effort to get back on track. Again, if the court felt that he was a danger to his own child, it would have issued a domestic violence restraining order. A lack of evidence is the reason why, and the finding that there was no threat of harm to the mother or to the child. That's why the case was dropped.
All right, I thank you both. This is a difficult situation. I will state that it appears in the response that the father has been proactive. I will state that he's proactive, and that doesn't include, it does seem like self-reporting, and all the assessments were done without input from other parties, not indicating that that's to his detriment or that that's not appropriate there. I'm just noting that it appears that those were all just self-reports. So I do want to acknowledge that I do appreciate the father being proactive after this incident. Clearly, this is, I think the parties agree that there is at least adequate cause as to a minor modification. The petitioner is requesting a major modification based on the circumstances. I was aware of the protection order, and I believe one of the parties included a copy of the denial of that order as part of their submissions. I was aware of that, independently aware of that.
And I think, Judge, that protection order in part was premised on knowing that there was and I wasn't involved in that. I don't know if Ms. Petrie was or not either, but court was made aware that there was a pending modification action. So I think, as sometimes we see in those protection orders, it was kind of shifted onto the domestic cause number for the adequate cause hearing and temporary orders, which we're here today on. So I think that's in large part why the court likely did what it did at the PO hearing.
Yes, and I will note that looks like it was retired Judge Warning that heard that case, and specifically as part of the minutes ruled that that there needed to be a motion for a parenting plan modification, and that this was not a specific domestic violence protection order issue, and denied the request. I frankly understand, and I'm sure all parties understand why Ms. Swanson may have tried to pursue this in that manner. I think it's reasonable given kind of the severity of the actions on the day in question. I completely understand that addicts, once you're an addict, you're always an addict, and you always are fighting and combating against relapses, and that relapses happen. I think hopefully there's support and understanding and a way to move forward after those incidents happen. In this case, yes, he was in his own home, but it became the problem of many because of the specific circumstances. And frankly, those circumstances would be alarming to anyone. And so I guess I understand the reason for the motion for adequate cause. I do agree that there is adequate cause to the extent that there's gaps in the parenting plan that need to be addressed that have just gone without resolution for an extended period of time. The specific request for adequate cause in this case, I am going to grant. I do think a GAL is appropriate to ensure the safety of all the parties, and the court does err on the side of protecting the safety and well-being of children in these circumstances. So I think it's good to do a check on what's going to happen here. So I will appoint a guardian ad litem in this case. And I would ask Ms. Wade to give me the next 3 names on the list.
So are you granting us to a major modification?
I'm granting adequate cause. I don't know where we're going to end up, if it's going to end up being a major modification, but I'm granting adequate cause at this point.
Your Honor, the next 3 names are Amy Turnbull, Ann Height, and Twyla Corey.
Mr. Zandy.
Right. I will strike Miss Turnbull.
All right.
And
And
For no other reason, I've got a lot of cases with her right now. I don't have an issue with any of the 3, but I'll go ahead and strike her.
Miss Corey, I'm sorry, Miss Petrie was your strike?
I'd like to go with Ann Height.
Okay. Understandable. So we'll appoint Ann Height in this case. The upside about that, frankly, is we can rest assured that we can get a quick turnaround on a kind of interim report from Miss Height. And not that we couldn't from others, but she's pretty reliable there. So we'll appoint her. I'd like to set a interim review of that GAL report. Does the 28th of November work for the parties? I know it's pretty quick, but I want this to be pretty quick.
Yeah, that'll be fine for me.
That's fine. And if we need some extra time because of the holiday, we got 2 coming up, we got Veterans Day and Thanksgiving, then I guess we can just kind of be in touch before the holiday and accommodate that if Miss Height needs more time.
That's I would agree, but I'd like to at least shoot for a little sooner rather than later. So I'm going to say the 28th, 1:00 p.m. For an interim GAL. Where is the child currently, or whom is the child currently with?
But the child was with my client as of September 6th, with the protection order being dismissed. I instructed my client that they continue on with whatever parenting schedule they had prior to the chaos on the 6th and prior to not having enforceable order. So they've been kind of patching it together as best as they could. I believe the child is currently with my client. My client is likely watching on YouTube and not Zoom right now, but I can confirm that.
Your Honor, my understanding is that it has been a week on, week off schedule for 6 years, other than this incident. I don't know who has the child currently.
Okay.
But I would say if that's the court, if this is the court, that the direction the court is heading, you could just maintain the status quo.
So, and I guess either party, and not necessarily Mr. Zandy. So the motion, which I just had up and of course moved away from.
My client is on here, Your Honor. Darren, can you unmute and let the court know who has the child right now?
Yeah, I got her Friday. I'm supposed to have her till this Friday.
Okay, so you guys exchange on Fridays?
Correct.
At what time?
Whoever picks her up from school picks her up from school directly.
Okay. And so you have her right now and you guys are exchanging on Friday?
Correct.
And so essentially last week, it looks like October 16th is when the denial occurred. So since then reverted to parenting plan.
Correct. Yeah. So I picked her up on
last Friday, whatever, the 20th.
Yes.
Okay. At this point in time, in this frankly there's things that need to be addressed. I think there's some concerns there. I do again state that I understand Ms. Swanson's concerns. Frankly, I don't disagree with her posture, given the circumstances around the incident. I also appreciate the proactive nature that Mr. Barnes has taken to try to address these issues, take care of them. We're in the middle of a week with dad. Last couple of weeks we're with mom. I'm gonna leave it at status quo to be reviewed on the 28th. If that date moves, then it moves. So status quo at this point in time, pending some information from the guardian ad litem. And hopefully that 28th date can stay and we can get some insight sooner rather than later.
Can we at least have a restriction from consuming alcohol in that interim
Absolutely.
parenting?
No
Yes.
objection.
No, and so no, sounds like I guess a couple things. So I guess an interim order, it sounds like the parties' agreement is pick up after school on Fridays. is the exchange time. So we'll just kind of mirror what they've been doing. Neither party to ingest any alcohol or illegal substances during their parenting time.
We're making that mutual.
No, actually, I'm not going to do that for Miss Swanson. I have no reason to limit her. I'm not sure that there's any concerns there. But for Mr. Barnes, given the current circumstances, no alcohol or any other illicit substances 8 hours prior to or during any parenting time with the child. And if there wasn't already, and I apologize because I have moved around so much in here, I didn't go back to the previous parenting plan. I don't know if there is, I think that if mother is concerned about any use by father, she can request him to do a UA. And I know that she asked for a hair follicle. He complied with that. So I'm glad they were able to work that out. But I do want to add that provision that if there's some concern, mom can ask for a UA, that would need to be done within, I don't know dad's work schedule, but within the day of the request. And if that UA does come up positive, that would just suspend that exchange. And then we'd try again the following week. All right. Do you want
Even of the GAL fees?
I'm going to do proportionate pay. So whatever their current setup is.
And we don't know what that is either. So
Yeah,
can
we
we just
don't
go
know what that is.
50-50 with reimbursement language?
50-50 with reimbursement. And if there's additional information about finances, we can readdress. And then do you want to set a presentation prior to the 28th or just leave everything on for the 28th?
Ms. Petrie and I could probably fashion an order, but maybe just keep presentation on for the 28th at the same time as that GAL review is. But in the meantime, I'll try to get a GAL order out tomorrow, just so we can get Ms. Height on board with that, so she has time to prepare.
Just so you're aware, Mr. Zandy, I am in trial all day tomorrow, but I can try to get to it as soon as I can.
Okay.
Okay, so well, then we'll set presentations for the 28th if we need to change that, or if there's other concerns. GAL review and child support.
Yes.
And I just received a big stack of stuff during the docket here that very well could have been emailed to me, but none of it looks familiar. I'm just going to be honest with you here. So
here's my proposal on this. So the presentation is pretty straightforward. Objections have been filed. Orders were filed a long time ago. Guardian ad litem filed her report, I believe October 12th or 13th. I was out during that period. I didn't see it till I got back in the office on the 18th. So I've only had it in my hands less than a week. As far as the guardian ad litem review, to me, yes, she's filed her report and I appreciate that. Mr. then filed the declaration yesterday. So what I'd ask that we do today is just do the presentation, but not, if the court's going to make any kind of changes to the parenting plan, that we set that over. My client should have an opportunity to respond. I should have an opportunity to chat with her and have more than essentially less than a week to review the guardian ad litem's report.
Thank you, Ms. Baldwin. I will tell you that the declaration affidavit that I do see was filed yesterday was not in Odyssey yesterday. It is in Odyssey today. I have been in court all day, have not been able to review, looks like it's 8 pages, but I think that's including
the visitation notes.
Yes. And just some Dropbox information, so that it may be less than that. I have not reviewed that. It popped up on in Odyssey this afternoon when I was able to look up this case. So I have not seen that, have not been able to review that. Ms. McLean, where are you as far as the GAL report?
Well, it's I received it the day that Ms. Kale filed it. I forwarded that to my client, and with his work schedule, he got back to me mid last week. And with my schedule, I wasn't able to turn his information around until I think it was Friday. But he wasn't able to sign his declaration until over the weekend. And then I have filed with the court the documentation that we finally received from the Cowlitz Indian tribe that has the 3 UAs that they have performed. They're on a color system. So my client has to call in every day. And then if his color is called, then he goes in for a random UA. So we've provided all 3 of those results, which were negative. We've also provided their assessment as far as what they're recommending for treatment and following through with, which is once a week for, I think, the next 3 months. And for him to continue with the AANA, which we've also filed with the court. And then this last week, Ms. Wishard asked my client to participate in a hair follicle test. Counsel's assistant forwarded me those results yesterday, so I went ahead and filed them since apparently they weren't going to do that. And clearly those showed a negative as well. So just like you had indicated in the prior case, you know, my client's been doing supervised visitation for the last 6 months. He has had, at least since he started treatment, at the time of his initial treatment, he had a positive UA for alcohol. We also had that hair follicle for the cocaine use in the early part of April, the last part of March. There's been no other substances other than you had the one UA for alcohol the end of August, I think it was, when he had the 2 shots of alcohol during his sister's wedding. So again, I mean, he's done he's doing what he's supposed to be doing. There has been nothing negative as it relates to any of the visitation notes, the supervised or the lay visitation. None of the visitation supervisors have had to intercede or step in to stop a visitation. None of the supervisors have suggested that Mr. Wishard was intoxicated or affected by any substances during his visitations with the child. So at this point, our position is that we need to progress forward. And I can appreciate counsel indicating that they want an opportunity to respond, but even Ms. Kale gives a path moving forward as far as unsupervised visitation. He is in treatment. He is doing the random UAs. He is looking into, albeit Ms. Lovely's report and recommendation, the court had not ordered my client to participate in services. We've had that report, I think, if I recall correctly, since the middle of June. And it was determined that he was not the aggressor in the, according to Ms. Lovely. So you haven't ordered treatment at this juncture. And your at least prior pronouncements were that you felt that his issues were the substance abuse, and that is also what came out in Ms. Lovely's report and recommendation, and that you wanted to see him progress there. I think he has progressed there. The visitation notes and Ms. Kale's report also indicate that Ms. Wishard is now having to bribe the child with candy at the end of visitations with my client so that she isn't crying because she doesn't want to leave the visits. It's emotionally difficult for the child to have these short visits and not to be able to spend more time with her dad and to spend time, you know, overnight in her room and things like that. So ultimately, we are asking that the court advance this forward to unsupervised visitation so that my client can have a normalized relationship with his child. And ultimately, we are asking for overnight visitation. He works a 4-on, 4-off visitation schedule. I don't know how long counsel's looking at having this matter set out. To be quite honest, I haven't looked at what the availability of court hearings are over the next couple of weeks. Oh, it looks like the next couple of weeks are open. But in any event, I mean, as you indicated in the case right prior to this, is you wanted to make sure that people were making changes. And I think you have evidence to suggest not only that my client has made changes, but that the limited visitation schedule has been difficult and emotionally difficult for this child, given her relationship with her father.
Ms. Baldwin, anything in response?
So it's up to your honor as far as I can just respond to the issue of whether or not we should deal with this issue today. Counsel sort of launched into her entire argument. But the reality is this is not an emergency. This is not a case where there's some impending doom if we don't make a decision today. And in fact, the guardian ad litem's recommendation is that he not have unsupervised time right now and then he not have it for 2 to 3 months. So the idea that we would force a decision today when you don't have the information that you could have before you, instead of put it out 1 to 2 weeks, that doesn't make a lot of sense. It doesn't make, court always wants to make the decisions that the best decision it can, the decision that's in the best interest of the child. There just isn't a reason to rush it today. And so again, I think we should set it out 1 to 2 weeks. Those dockets are open. I think that's an easy call. So I'd ask the court to just set this issue over, again, 1 to 2 weeks. If the court's not going to do that, just let me know and then I can launch into a substantive argument.
So I don't have any closed dockets upcoming. I do have availability the 31st. I have availability I think it's the 7th. And I would agree with Ms. Baldwin. This is not a case where there's not visitation happening, that there's not communication, there's not contact is still happening on a regular basis between these parties. I did review the GAL report. I do think it's appropriate for everybody to have sufficient time. And I, again, have not read the declaration that was filed by Mr. yesterday. So if Ms. McLean wants me to consider anything in that, I would need to set it over.
Okay.
So, but I can do it just 1 week if that works for all the parties. I agree. I don't want to delay this, but I also agree that we are in a situation where the parties, there is visitation happening. So it's not, but I mean, we can set it to 1 week. We could set it to 2 weeks. Both of those are open at this time.
I'm fine with either.
I think my client would prefer to have it heard sooner rather than later.
Go ahead.
I just want to confirm, Ms. Wade, I know we've set a couple over from today. Are we still good for next Tuesday, correct?
Yes.
We are, yes, we're at 17 and 20.
Okay. So 1 week, we can set the GAL review 1 week, and then I'll have an opportunity to review Mr. Wishard's declaration. I'm sure, sounds like he would prefer that I be able to review that. As to the, okay, I have two, let me,
so the only thing that you should have from me should be a child support worksheet with a cover sheet with my footer on it. And then I also filed objections that included those worksheets back on October 10.
Yes, I have that. And then I have from Ms. Baldwin, the child support order, as well as one child support worksheet. And I do see the objections and have those in front of me that were filed on the 10th. And I guess, Ms. Baldwin, was anything changed from your proposed orders based on those objections?
No, what I can do though is I can go through them pretty straightforwardly. So the first objection is the request to add Washington paid family leave. I did note that I left those $63 out. I can add that back in. The balance of the objections are tax strategy and payment strategy. So when the court set the incomes, the court didn't say, and put him at, a single payer for taxes, put him at head of household, put him at married. And when the court doesn't do that, and the court doesn't commonly, to be honest, do that, then I think what you see is some gamesmanship on how the taxes are run. And how the taxes are run impacts sort of the bottom line of how much income a person has for their child support worksheet. I ran, my client's income is all imputed. I ran her at single. I believe I ran Mr. at single or something close to single. And so that's how I ran my numbers. Ms. McLean ran her numbers at her client single, sort of trying to maximize his taxes to drive down his income, and running my client at head of household, inflating her income, which again is all imputed. It's not real income that she actually has. So when you look at it that way, that's really the balance of, those are the substantive objections. The practical effect of all of that is that Ms. McLean's bottom line is about $200 different than my bottom line as far as what the actual transfer payment is. So I have a transfer payment of $1,244. Ms. McLean has a transfer payment of $1,041. So again, almost exactly a $200 difference between these two parties. So the court just
could I interrupt for a moment, because that's different than the calculations that I have under your proposed orders.
When I looked at the proposed orders,
your calculations show 1,088.
Hold on.
And that's what your child support order shows.
Yeah, on lines, or excuse me, I guess part 17 of page 3. I have $1,088.74.
Okay, let me just confirm.
I just wanted to make sure I've got the same thing.
Yeah, sorry, I must have updated it at some point. I might be looking at an older one that we had filed. That was an older proposed one. So again, if it's 188, the numbers between the two are we're only $40 different, which is a very modest difference. The other objections that are raised in the Ms. McLean's objection, to be done in equal installments consistent with this pay period, that's fine. I usually write it to be done on specific dates, but essentially we all bow to the Division of Child Support and how they take it. So you can write that in. I have no objection either way. The reality is it's going to be done per how the Division of Child Support takes it from his wages. On paragraph 17, on when child support will terminate, council has selected essentially the final language, and I selected the temporary language. The current supports to be paid is because this is a temporary order until another order is entered. That is what the correct selection is. Council's proposed language is really for a final order. As far as the health insurance language, I believe I've selected the correct health insurance language. I believe it's more correct than what council's proposed. I don't think, but I think that's a distinction without a difference, to be honest.
So just briefly in regards to the child support calculations, to be quite honest, I'm not certain how council ran taxes for purposes of her calculations. She suggests that if you look at her line 2A in the calculations, she suggests that she ran her client as single with 0 child credits. She doesn't indicate how she ran my client. I ran my client as single. And not claiming the child. I ran Ms. Wishard as head of household and not claiming the child because the court hasn't made those determinations. But clearly she's head of household. She's going to qualify as head of household. So that's where I arrived at the tax withholding from my client of $1,662.76 and her withholding of $99.28. It is accurate that my client does pay Washington Family Leave. His employer has enough employees that he doesn't have to pay for the long-term health care, from what I understand. So I have not included that. So that's the difference in the calculations. I agree that the bottom line is about $45 difference, which is a class and part of a potential UA for my client, which is significant considering he has ongoing at least $150 per month for the substance abuse classes, and he will have probably another $150 per month if you end up ordering him to do counseling recommended by Olivia Lovely. In regards to the child support order, the primary difference between our proposed language is the fact that I'm using the July 2022 updated forms. Council's order is still under the old 2021 forms. And so the Pattern Forms Committee updated language after input from all of the involved participants, particularly Washington State Support Registry, to make sure that they're able to enforce certain provisions. So my proposed changes to her order are at paragraph 5 to change their respective incomes. My proposal was that his income be changed to my calculation, which is the $73.50.88. Hers changed to $24.18.34. Paragraph 8 to change Ms. Wishard's basic child support obligation to $391.06 and my client's basic obligation to the $1,040.94. At paragraph 11, it appears it's agreed as far as the equal installments consistent with my client's pay period. At paragraph 17, the new language under 22 provides for there is no more temporary language option in the child support order. It's simply the paid by until the child turns 18. And my assumption, I can make some assumptions about that. I think that there were too many orders where that wasn't getting changed on final orders, and WSSR was having to go back and have people change that because it still had temporary language in it. So the Pattern Committee did away with that language. As it relates to paragraph 20, again, the pattern language that was adopted by WSR, and technically Ms. Baldwin's order has the first 2 sentences, or actually the first, so the bolded language, and then she has the one that starts Jonathan Wishard, and the court has considered. What needs to be added is the parents must enroll the child in accessible health insurance coverage through their employer or union up to 25% of their basic support obligation. DCS or any parent may enforce this requirement. And again, that's language that was promulgated at I believe at the request of WSSR, because all parents are obligated to provide health insurance unless it's specifically waived by the court. And the court hasn't waived that requirement for Ms. Wishart at this juncture.
Thank you. Anything further, Ms. Baldwin?
If that explanation had been provided a little more succinctly in the objection, I would have just snagged a new form. I didn't realize that I was using one that was a couple months out of date. So that's fine. We can make those changes. The court can pen and ink it. I think that they are largely distinctions without differences, other than the court choosing between the $40 or so on the transfer payment.
So as for the paragraph 11, 17, and 20, I think I would agree with Ms. McLean, and it sounds like Ms. Baldwin doesn't have a significant concern with 11, 17, and 20. If we're on for next week, can those changes be made in a new order so this one isn't totally gummed up on the new form? Is that?
Yes, that's fine. Okay.
And then as far as paragraph 5 and paragraph 8, I guess with the addition of the 6341, which again, in the worksheet, Ms. Baldwin agrees was left out and would be added in. I don't know how much impact that would have on the total numbers, if we would then, both parties would land at the numbers that Ms. McLean is proposing in the child support order, or if we'd still be a few dollars apart. But frankly, I have to say this is probably one of the closest numbers that I've come across. It's usually there's much larger disparities. So just want to acknowledge that because we don't see that all the time. Hold on one second. So I've reviewed the worksheets that were provided by Ms. McLean and the worksheets provided by Ms. Baldwin. And we, as I stated, we're very, very close. I don't, given the 6341, I'm going to assume that, I'm not going to assume. I'm going to ask that the changes in paragraph 5 and 8 be reflected to show Ms. McLean's numbers there. I think it's nominal difference, but if we could have a new order for next week, I will sign off on that. And as we stated, it's, I think in one area it's $18, in another area it's around 40. So
is the court just going to sign off on my worksheets then?
I can sign off on the worksheet, and if we want to have a new order Tuesday,
sure.
then I can.
The only thing that I would note is that it appears that, and I just saw this when I was flipping through them, it appears that I forgot to remove language from our original proposed worksheets at paragraph 26 as far as residential credit. Would you mind just striking the language in paragraph or in box 26 on page 4?
In its entirety?
Sure.
It should be.
Okay, I'll just line through 8 and initial on a motion for temporary order based on our GAL recommendation. And I have reviewed the GAL report and all the filings. Let me just double check because it seems like a lot of the cases have had surprise declarations in here. So looks like the last thing was filed was just an affidavit of mailing and a reply declaration on the 19th. And
are you referring to petitioners?
It is petitioners, yes. And I have reviewed that, and that was in the file. So I believe I am ready to hear argument.
Thank you. It's our motion. Given the time of the day, I'm assuming you read it all. It's a pretty straightforward motion. That is to basically adopt the GAL recommendation, which is a shared 50-50 schedule for this child, Henry, with exchanges on Friday. We basically followed it to the T. We've done so because the report, in our opinion, was thorough, covered all the different areas, was pretty unequivocal about what they found, supported by the therapist for Henry, who also indicated in the report no reason not to have a 50-50 schedule, supported further by the counselor for my client, who said there's no problem with Henry living with my client, and quite frankly, supported by Henry himself, who in the order or in the GL report said to the GL that he would prefer an equal schedule of quote unquote 4 sleeps at each home. So I think it's time to adopt his schedule. My client's been seeking this for quite some time, and there's nothing, unlike other cases I've heard today, there's nothing particularly overly controversial. Both seem to be good parents trying to do a good job for Henry, and Henry should benefit from being in both households as recommended by the GL. And again, out of consideration of the time, I'll stop at that point, unless the court has other questions for me.
I do not. Thank you. Ms. McLean.
Thank you very much, Your Honor. So obviously you've seen my client's reply declaration that was filed back on October 10 of this year. I do note that Mr. Anderson's reply declaration, which was filed on October 19th, submits a number of new allegations that my client has not had an opportunity to respond to. Obviously, the concern is that my client has substantial substantive arguments as it relates, or information as it relates to a number of the information. I guess my question would be is, would the court allow me some latitude as far as responding to some of those allegations? Because I don't, at this juncture, I know the court has read that. I don't know what you are relying upon as far as making your ruling, but obviously if you've considered the new information without my client's input or opportunity to respond to that information, that's concerning, for at least from my client's perspective. So I guess I just need some direction in that, whether or not you'll allow some latitude to allow me to respond to some of those new allegations.
Could you just, there's a lot of sort of back and forth here. So what are the specifically, what allegations is your client specifically concerned with?
She was concerned about, first off, about the suggestion that she had kicked her older child, Renoa, out of the home, and that Renoa has recently returned and is pregnant. That's none of that is accurate. She was concerned about the suggestion that that she has disclosed a new dating partner to Henry. My client is not currently dating, and she hasn't seen her former dating party for over 7 months. It was admitted that my client did not meet with Jeff Ritchie, which is Lucas's counselor, although that was stated specifically by Lucas's counselor to the GAL, and there were statements attributed to my client during that, of which my client clearly has never met with that individual, so that's concerning. There are statements about ongoing conflict within my client's home, but Lucas has not been in my client's home and has no basis for making those suggestions. And if we're relying on child hearsay, there's certainly been no sufficient factual information to support an alternative to that hearsay statement. There's a suggestion that there was mediation offered over the soccer. There's no documentation to support that claim. My client denies that there was any offer to mediate soccer. And Lucas claims in his recent declaration that he did not sign Henry up for soccer, but bank statements that we just received showed that he paid $75 for Henry to be in Castle Rock soccer. There is a suggestion that Henry was recently gone for 5 consecutive days from school, that he was gone for 20 to 21 days the past school years. I've seen no evidence to support that. My client would respond that yes, recently the child was out for 5 consecutive days. One of those days was during Lucas's time because the child was ill. And in fact, it was my client who called the school to make sure that those were excused absences because of the client's illnesses. Lucas suggests that Henry was not with Erica, his girlfriend, for more than 4 hours. Well, he doesn't state for more than 4 hours. What he says is that the child was with Erica while he was at his grandfather's funeral. My understanding, at least from reading that on first blush, was that, well, it was a short funeral, it was less than 4 hours. My client's information to you would be that, in fact, the grandfather's funeral round trip was more than 4 hours away, and my client was not offered the right of first refusal, which is ordered under the existing parenting plan. My client has no idea what this supposed tampon story is with the teenager chasing Henry, never heard it before, has no information about that. My client does not allow Henry to participate in making decisions about his visitation schedule or encouraging him to call Lucas about visitation schedules. So that would be, in sort of a bulleted response, her response to those various allegations. I think it's clear substantively, when you go back and look at the history of this case, that there continues to be conflict between these parties. Even the guardian ad litem acknowledged and sort of admonished Lucas's behavior when Lucas was working at the Castle Rock Elementary School for interceding Henry when he was coming to school from my client's residence, swapping out his school lunches, making him change into different clothing, and she indicated that that should not be happening. And now, even though Lucas is teaching at Kelso, within the Kelso School District, he continues to go to the school and intercede and meet up with Henry prior to school or during school, and we're not certain in what circumstance that is. I know that Lucas claims in his declaration that that's because Erica, his girlfriend's children, attend Castle Rock School. But I guess my question is why isn't Lucas at school teaching in Kelso during those times? And why do we have that interception? There is a concern about the child being exposed to social media. My client relays to you specific incidents that she had disclosed to the child's counselor about Henry talking about watching a TikTok video of kids who use hand sanitizer, light their hands on fire, and you don't get burnt, Mom. He's not allowed to engage in social media. He doesn't have a phone of his own at my client's residence. Any television that he watches is monitored by my client. She did provide for you the photos attached to her reply declaration of some of the social media snippets that she was able to take and provide to you. She doesn't have Henry's passwords to his social media. That hasn't been shared with her, so she's not able to monitor that. But we're talking about a 7-year-old. And that's very concerning to my client that this child has talked about various things that are age inappropriate that could potentially lead him to engage in harmful behavior. He's talked about observing violence and nudity, and that is all very concerning to my client. We were before Judge Hahn this last year, basically on this same motion. And at that time, Judge Hahn, she issued an initial ruling and then perceived that one of her statements might be taken inaccurately. And so she corrected that and provided an amended ruling. And basically her snippet or decision at that point was that, look, there's a lot of conflict here. This child needs stability. The court's main interest is ensuring that the child's best interests are taken into consideration. And we think we're in the same situation at this juncture. There is still conflict going on. We have Lucas not following the parenting plan. We have Lucas continuing to engage the child in efforts to change the visitation schedule and call my client to talk about he wants to stay longer. That's inappropriate. To involve the child in the residential schedule. And quite frankly, it's in violation of paragraph 14E and 14F of the visitation schedule. That's something of the parenting plan, pardon me. That's something that the parents are to talk about. Adults talk about those issues. They don't involve a 7-year-old child. The other concern, even with counsel's argument about, well, the child said to his counselor that he wants to have 4 sleeps at each house. How many 7-year-olds do you know engage in that type of language if they've not been exposed to parenting plan discussions by one of the parents? There's not very many kids that have a wherewithal of they want to have equal sleeps. You know, what does that mean for this child? Especially when he knows that he has a secure environment with my client. He knows that he goes to school from my client's residence. He knows what the visitation schedule has been since the latter part of 2021. He's been operating under this existing schedule for the last 2 years. And so just like Judge Hahn ruled previously, we're asking the court to rule similarly, that the trial judge needs to have an opportunity to weigh the credibility of these parties, to listen to all of the evidence, and to make a determination of what's in this child's best interest, and that it would not be appropriate on an interim basis to make sweeping changes given the ongoing conflict between the parties. So we're asking the court to essentially find that there's been no substantial change in circumstances, that there still remain concerns as it relates to at least portions of what witnesses have told to the guardian ad litem that potentially she's relied upon, particularly Lucas's counselor, as far as making statements that he actually met with my client and that my client was opposed to being married to a man, and that Lucas was transitioning to a man, and therefore that was the conflict between their marriage. My client never met with that individual. My client has never made those statements. My client is supportive of Lucas making those decisions. My client has not been supportive of the manner in which Lucas has exposed the child to these decisions without having appropriate therapeutic background and support, without having appropriate discussions at a child level. So that has been those concerns. Obviously, those are bells that have been rung and cannot be unrung, but we still have the ongoing conflict, and we're asking that the court not make those changes at this juncture. The trial court needs an opportunity to weigh both of these folks' credibility.
And there's an upcoming, it looks like a trial setting for an MSC.
Yes.
So we're still pretty far out from
We are.
to a trial date. Okay.
And Your Honor, briefly, if I may, I don't have much to say. I'll just say this. This is the problem. These little things, soccer and these things, that's not the meat of the issue here. We've hired a GAL. She's come in, done a deep analysis. She's given you her recommendation. These are all red herrings that throw you off the scent of the bigger issue, which is we do that deeper investigation to give the court a sense of what should be done. And what should be done here is the 50-50 schedule. We're in front of you. We're not in front of Judge Hahn. They previously ignored or got past the other GAL and got to you, which I wasn't part of that. But we went through these steps to get to this point today. We don't know when trial is going to be set. We should follow the jail's recommendation. These little issues, which counsel calls contested, are not even in the same realm of the things I've heard in other cases before you today. And they're things that are, quite frankly, common between parties. I would also say, if you want to hear from my client on all the things counsel just introduced, my client was just responding to their response. I'm happy to provide that. I just think it takes us into all these other areas, which ignores the bigger issue of the schedule, which should be imposed as a 50-50 per the guardian ad litem's recommendation that this court brought to bear in this hearing today.
Thank you. Ms. Corey, I appreciate you being here. It's been a long afternoon. I apologize. Anything that you feel you need to weigh in on, and then I'll ask if, I don't know if either counsel has any questions of Ms. Corey.
I do stand by my report, and I'm frankly was rather surprised to be back here because I had signed a agreed order.
You know, I would object to
September.
the item bringing up any settlement negotiation attempts. Those orders have not been entered. They did not agree to those.
Okay, so I guess move on from there, Ms. Corey.
Okay. I stand by my report.
Okay. Does either party want to ask Ms. Corey any questions?
I have no questions.
Okay. And let me see here. We're about a year-ish away from the court's reconsideration, and we're about a year and a half almost away from the previous GAL report. And a new one was afforded. I want to think February of this year, a new GAL was appointed, and that process was started again based on a lot of different concerns and issues. I believe we're working off our most recent parenting plan is from August of 2022. Is that correct? Yeah. Okay.
Yes.
I will, there's a date of, I believe I saw November 1, it might've been November 7th, an upcoming date for trial setting. I think it's next Wednesday for scheduling an MSC, and knowing how far those are needing to be set out, that puts us a pretty significant distance from trial at this point. So we're
unless the court waives the MSC. I mean, we have attempted to resolve without success between counsel and I. So if the court wants to waive MSC and allow us to proceed to a straight trial setting, we can certainly do that as well.
Well, you can imagine my response. That's a response because she's hoping you don't adopt the 50-50 at that point, given the trial being out so far, which I just can't rely on.
And I'm only relying on what my recent history is with some of those dates setting. For all I know, you could get an MSC in November, because there are some dates that have opened up, but I know that there is also scheduling that's out a little further. There's a few issues that I think do need to be addressed. There is a joint decision-making in all extracurriculars and everything else. Clearly, there is a disagreement as to what limitations this child has as far as being able to participate in some of these extracurricular activities. I think most recently it was soccer, and what that means, the diagnosis, and if that's something that can happen or should be allowed. And as I stated, there's a disagreement there. We need to figure that out, because this child shouldn't just be sitting here doing nothing because that hasn't been determined. I think there's a few concerns with how Mr. Anderson has addressed some of these issues. I frankly don't like the interference that's occurred in the school, regardless of whether that was his place of employment. It's no longer his place of employment. And so there are some concerns there, but there's also, I have some mutual concerns of some of the activities. I would agree with Mr. Brower that there is far less concerns in this case than a lot of the other cases before the court today, and on a regular basis. Both parties seem very actively involved in this child's life. One of the things I did note is wanted some clarification on, did Mr. Anderson adopt that other child that's?
No.
Okay.
And he's not had contact with the child since then.
And that struck me as kind of interesting in some of the comments from that child, if there, and I guess I was under the impression that the adoption was completed, but if it was not completed, then it's a little bit of a different posture, but still a little bit concerning. There is nothing in the GAL report, nothing that has been filed that would make the court feel that either parent is detrimental to this child. Clearly, there's some concerns with how they operate together in parenting the child, but again, far less issues than in a lot of cases, unfortunately, that we see. So that's positive. I've reviewed Ms. Corey's report. Ms. Corey's report is very detailed. There was over a dozen folks that were spoken with, probably well over that number. And we're a year out from the last request, and even longer than that out from the last GAL report, probably closer to a year and a half out from that last GAL report. I do think it's a fair recommendation. I don't always, I know a lot of times people think that the court just openly adopts all GAL recommendations. Frankly, I'd like to see more parenting plans on a 50-50 basis. I think there does need to be continued joint decision-making, especially for extracurricular activities. I think we need to have a definitive medical recommendation for sports activities. So if the child's primary care physician says, yep, they can participate in soccer, then guess what? Child can participate in soccer. If it's no, then it's no. But that needs to be determined by the doctor and not usurped by one of the parties because they are worried, scared, nervous about it. If this child wants to be active in extracurricular activities, that absolutely should happen, assuming the parties can agree on it and it works with everybody's schedule. I also would indicate that there should be no romantic partners for the first 6 months of any dating. I understand that Mr. Anderson is already engaged in a new relationship and that individual has already been introduced to the child in question here. I do think that the parenting app, Our Family Wizard, or Talking Parents, or app Close, I'm not familiar with that one. I'm familiar with Our Family Wizard and Talking Parents. Either one of those is a very good option. I do appreciate that you can upload calendars and do all that kind of stuff on there. So I think it's appropriate that they utilize that moving forward.
And I think they're using the Talking Parent. I think
they're already using Talking Parents.
I believe so. Mr. Brower, do you know off the top of your head? Oh, so yeah, it's Talking Parents that they're using, and the app Close is a free program.
Okay,
it's a different free program.
So if Talking Parents is already utilized, I know Our Family Wizard and Talking Parents both have calendar functions and sharing calendar functions, which I think is great because everything's just there and can be updated by either party or made notes. So I think that's a good way to move forward. Obviously, the parenting plan going to a 50-50 would be a pretty major change. The child is in counseling. I'm going to assume that, I guess I'm not considered. I want Miss Anderson to understand that the counselor that indicated that she doesn't want to be with a man because of her past trauma or whatever the allegation was, I'm not concerned with that. I don't think Miss Anderson has shown any actions that would fall in line with those concerns. She seems to be have been very open and accepting of this transition process, and that doesn't really kind of hold a lot of water. I think that has been one of the smallest issues, if an issue at all, in this case. And so I don't want to. I just wanted to clarify that since that was a concern. But I do think that given everything, the counseling comments from all the parties and the incomplete report of the GAL, given the posture of this case, where we're at, I think it is appropriate to adopt the recommendation and transition into a more of a 50-50 process. The recommendation is a transition from Fridays after school, I believe.
Right.
And I don't know whom currently has the child.
I assume my client does.
And I don't know if this Friday would be a normal week for Mr. Anderson to have the child or if it's an off week. But essentially what I'd like to have happen is if it's an off week, I want it to remain an off week. And the next weekend that Mr. Anderson would have the child, that be when the switch occur. So
First, third, and fifth weekends. So this is the fourth weekend.
So next, the third would be the first weekend, and then on the third, we'd be going to week on, week off.
Okay, very good.
And any dates that we are not available for presentation?
Can we also suggest, given the child's age, that there be a midweek visit for the other parent?
Is the child still in Castle Rock?
Yes.
And I know that Longview has early release Wednesdays. I know Wednesday's often the day that because there's early release, but I don't know if that is Castle Rock or Kelso, if that applies to them as well.
Yeah, I need to get more information from my client about that. Perhaps counsel and I can talk that through, because I don't know the logistics of that and how we would pull that off. So
I think it is appropriate, and I would agree with Ms. McLean. This is going to be a larger stint of time for a young child to be away from both parents, especially the parent that's been primary. So I think a Wednesday visit is appropriate. The parameters of that, given school and all that, if the parties can work out, great. If we can't, then I'm happy to resolve that at presentation.
And I guess my suggestion would be that we just have Wednesday on the off week would be an overnight visit.
Yeah. Maybe we hear from the JL on that. My concern is, I think some separation, the less contact, and what we've already talked about the issues the council thinks they have. To go overnight kind of defeats the purpose of more continuity I think we're trying to achieve. But maybe the guardian ad litem has an opinion on that. I don't know.
Well, I'm anticipating that it would be Wednesday after school to Thursday at school. So that would eliminate them having to exchange. The exchanges would be directly at the school.
Yeah, I don't know. It seems disruptive to me, but yeah, maybe the guardian ad litem has thoughts on that, because then you're back to Thursday, and then you're back to the other one to go back to the Friday, and
Ms. Corey.
I guess my question would be: is that Wednesday? Is that for both parents?
Yeah, off week Wednesday for both parents.
Okay. Most typically, we see the one where it's a dinner visit, 4 or 5 hours on a Wednesday. I would not, however, be opposed to the overnight, given Henry's age.
How about this? I agree with Wednesdays to Thursday is pretty close to a Friday exchange. What if we did Tuesday after school to Wednesday at school? That's a little bit less time, but it breaks up that week a little bit more evenly, and there's not a transit. I'm at this place, I'm at that place, now I'm back at this place at the end of the week.
Yeah, the only disadvantage is that you don't have an early release, but if that's what the court thinks would be appropriate.
I'm fine with Tuesday after school to saying Wednesday at 6 p.m., Wednesday at 7 p.m. What is the age of the specific age?
7.
And I think the issue is good if you add a time after the Wednesday. Now we're back to the exchanging. I think if there's going to be an overnight, my preference would be the exchange through the school. I mean, that's simplest.
Here's the deal. I've said this many times today. I can't express, I know it's my job, but it's frustrating that little things like this can't be worked out amongst people that chose to have a child together. You need to grow up, learn how to co-parent. The child deserves to have both parents in their lives, and the parents need to try to work together to be at least civil. I haven't read anything that says that there's physical threats, that there's anything like that nature as far as any exchanges. I think an overnight visit for a young child is appropriate midweek. I would say Tuesday after school to, I'm going to say Wednesday at 7 p.m. If the parties don't feel that that's something that they can accomplish without conflict or concern, then that's something that the court is going to look upon pretty stringently when looking at any changes in the future, or potentially even just removing that midweek visit altogether, which frankly, I think would be a detriment to the child. So my hope is that they can figure it out, work together for the best interest of the child. It benefits both parties and their off week to have, that period of time with the child.
And I'm sorry, what date did you set for presentation?
I didn't, but any days available. The 7th? Is that too soon?
No, I don't think so.
Does the 7th work at 1 p.m.?
Yeah, I think that's fine.
Okay, we'll set presentation for the 7th at 1.
Okay.
Thank you.
So I'm clear. Will I have counsel and judge? The alternating week starts on the 3rd. I think we said, right? And then would the Tuesday start next Tuesday? Then considering the same.
No, the new parenting plan will essentially take effect the 3rd. So the first
right,
Tuesday
we are
overnight
here
will be the 7th.
for-
of November.
Very good. Thank you.
Hold on.
Motion for protective order.
Correct. Motion for protective order based on discovery requests. And I have. My Odyssey is like, this is the
So
worst
that's
time.
fine. I didn't file a reply. My reply is really just argument. So I'm just prepared to make argument and go through essentially her arguments and dispel them, dispatch them in argument.
And I'd object to that, Your Honor. Washington is a pleading state. If there was an objection, it should have been put in writing.
That's not required. If it's just based on the law, I don't have to file a memo. I would need to file pleadings if I had factual statements to make. And there's previous pleadings directly on point on this issue and declarations that have previously been filed. I don't have to regurgitate those. So I'm prepared to go forward. Again, these are really straightforward issues. Counsel's arguments generally just fail on the merits.
All right, hold on. Let me motion for protective order that was filed on the 26th lists out the specific request for production that you have concerns with. And I've reviewed all of those. So, and I did make notes. Let me grab. So specifically, we have request for production 1, 3, 5, and 6. Is that correct? Is that just those 4?
Yes.
There's 4, yes.
Okay. Okay. Ms. Jeffers, do you want to make any additional argument?
I don't think so, Your Honor. A lot of stuff has already been turned over to opposing counsel, but specifically with regard to Mother's social media and Google, we want to start limiting the amount of information. I'm also awaiting subpoenas for text messages between the parties. At this point, I think I'm over 35 hours just reviewing the initial stuff. This is a basic parenting plan case. This isn't a civil fraud case out of New York, and the parties both have very limited resources. Additionally, at this point, a lot of it is not relevant. It's overbroad with regards to the social media and Google. There's no time limit. It's from the beginning of time, and that's just not appropriate. So we are asking for a limitation on that. There's some really big concerns here as far as information on other children, their locations, where they go to school, their schedules, things like that. There's medical information about other children. And not only is that not relevant, but it's pretty scary to hand that over to somebody who has been convicted of multiple violent felonies. The tracking information is also problematic. Information requested is location of where Mother is every time she accesses her phone, things like that. I don't know that that's relevant, especially going back as far as it did. And given the domestic violence concerns, there's serious concerns about how that information would be used by father. The other, basically kind of 1 and 3 go together, the same arguments, and then 5 and 6. With regard to 5 and 6, this is text messaging, mother and child. At the 26I, we talked about just limiting the communications between mother and child. I haven't heard anything from opposing counsel yet on that. That's what we're trying to do. The court has previously ruled that father doesn't just get access to the child's everything. Specifically, that argument came with regard to Facebook. So we've already turned over the communications between mother and father. I did submit some information on messages that father has sent to child, and there are concerns of how father is going to use these. As you can see from the messages, it's basically, I'm going to punish you, your life is not going to be happy, those kinds of things. It's a very significant power and control dynamic that's going on with father as regard to the son. And the child's already, the GAL has testified, is having a horrible time in this situation, and is acting out, is shutting down. And again, there's concerns on how that information would be used. There's also concerns, again, these are messages with, some of those messages are with other children, and information with regard to those children, their addresses, where they like to hang out, stuff like that. I'm not sure how that is relevant to this case. And again, I think it's too overly broad. Again, location information, where the child is at every time. But I mean, those are the major issues, Your Honor. We're just asking to limit the time to say 1 year. I think previously it was 2021. I can see what I can do there. Limit the tracking and location data, the information regarding other children, limit the communications between mother and child. That's appropriate. And I think that that will do it. Thank you, Your Honor.
Thank you. And I'm just going to state for the record quickly, Ms. Baldwin, then I'll turn it over to you. So request for production number 1 is a complete archive of social media accounts. And these are the ones that are at issue. Number 3 is archive of Google account, except email, including name or in which you have access, including digital copies of account history and archives. Number 5 at issue is, oops, I skipped over. Electronic native copy of information available on each page of Jaden's text messaging and her instant messaging services from January 1, 2021. And then number 6 is electronic native copy of text messages and instant messages from, I think, Ms. Vick from January 1, 2021 to present. So I just wanted that on the record. Ms. Baldwin, go ahead.
Thank you. That's fair. So you really have to go through. So first, discovery is broad. It's very clear under the court rules that discovery is designed to be broad. And the only way you can limit discovery is if it's done for some improper purpose. They don't allege that. They don't allege that at all. The second, you could have that if it's unduly burdensome, and they don't get to that either. So when we look at things like request for production number 3 and request for production number 1, which are essentially downloads, this is not the Exxon Valdez in the 1980s, where I'm asking for a truckload of printed documents to be delivered to my office. It's a link that you click and then you download it and then you put it in a Dropbox. It's a 5-minute process. Nothing on there is privileged. So if it's not privileged, it's discoverable. And in this case, they even admit that it's relevant. And so again, their arguments fail. They say, well, not everything in there is relevant. Relevance is not a bar to discovery. And they straight out admit that some of it is relevant. So if it's relevant and it's not asked for an improper purpose and you can't show that it's unduly burdensome, you have to provide it. It's very clear. Again, this is broad discovery. Counsel, like, well, I've spent hours and hours going through this stuff. That's her choice. And that'll be my choice on what I go through and what technology I use to glean through that information. But it's not required because it's not like she's going through it to create a privilege log. Nothing in there is privileged, especially with the social media and the Google logs. And that's like why we intentionally excluded the email. I didn't want even a chance that I would accidentally happen upon an email that would be privileged. So we've excluded everything that's privileged. So all that's left is stuff that's relevant that they admit is relevant. Again, they say directly, not all of it is relevant. And I'm sure that's true, probably all discovery asked for. Not every page of the ream of bank records is relevant. It just isn't. But some of it's very relevant to the case. And that's what we're looking for. So again, their arguments fail there. Then they make these very weird fictive arguments about other people may have some concerns. They don't list any individual person by name. There is not one of those people who's come forth today. There's not a single declaration of a person saying that they're concerned or afraid. So this is just mother casting the specter of, gee, maybe some information that other people might be concerned about might get out. But again, this is all things that they've put on social media. These are all things that they have broadcasted to the world. At some point, you can't really complain when you've put that forth to the world. Again, costs, there's no cost affidavit and fee affidavits here about time that has been spent. And arguably, when we're talking about a link that you download the material and you send it because nothing in there is privileged, it isn't costly. You're choosing to go through all of it, and that's fine. But the procurement of it is not costly. And that is the question. It's not how much it costs them to go through it. It's the procurement is the question. The next sort of specter they raise is he'll use it to track her. There's no evidence this has occurred. There's no evidence this has occurred essentially since my client was convicted, spent time in custody. He's gotten out. He's done everything he can to stay away from her. The only evidence that they say exists, or there's been a photo of her home. And I will tell the court that the single photo of where Mom lives in Cathlamet was done by my investigator, not Mr. Rance. So again, we have this specter of he'll misuse it, but no evidence he has at any point in this case done anything to track her whatsoever. And when we look again to the text messages, and I'll tell the court, I did not time limit the Facebook and the Google because I think it's harder to time limit it with the link than it is to just say, send it all. So I actually tried to make it easier. If the court wants to put a time limit on it, that's fine. I think I offered to put a time limit on it in our CR26. I made multiple offers across the board to try to solve this problem. And that's part of my declaration that's previously filed. I said, we'll put a time limit on it. How about it's only accessible to me and my staff, and my client can't even look at it. None of those answers were accepted. So again, when I tried to solve the problem, offer time limits, all rejected. So again, there's no real excuse as to why they haven't provided this, other than it's negative for them. Next, we get into the text messaging. The text messaging is critical. They themselves use text messages to prove their point. So they're fully admitting they're relevant, fully admitting that they're useful for the purposes of litigation, but they say, but don't make us provide them because that would be bad. But there's no evidence whatsoever that it's asked for an improper purpose, that it's harassment. Those are specifically time limited to the time period where this case has been in litigation. So again, we're really dialed into the time period where my client's been asking for time with his child. So we're asking essentially for mom's text messages, specifically with child, mom and dad's, or child and Mister's text messages, and mom's text messages to the broader world, child's text messages. These will give us the scope of who is feeding information to this child, who is sort of swaying the child one way or the other. Counsel sort of makes the argument that children are swayable. I agree, they certainly are. And these text messages are the types of things that will give us that information. And the native format is important because the information that they use is completely undated. We don't know when it was, how it happened. So again, you're getting sort of this mishmash of, well, this is when she says it happened, but no one's really quite sure. So again, that's relevant. They admit it's relevant. They just don't want to provide it. So again, the reality here is that it needs to be provided. They raise essentially, it's a lot of cut and paste through each of these of sort of raising these same specters. The argument does not change. So again, we've done our best to limit it time-wise, limit it as when appropriate. But again, these are not things they're even being asked to print out. And the things they've provided, they haven't printed out. They've provided to me on thumb drives. They could provide it to me in Dropbox. So again, really straightforward and simple. So again, I'm fine if the court wants to add timelines to some of the social media and the Google accounts, that's fine. All the rest of it, I believe, is time limited to 2021 and forward. This is a situation where the court should deny the motion and award fees for me being here today, especially in the case where there's my declaration where I offered all of these solutions to these problems, and it was just, no, I'm not going to do it. That's not reasonable. Parents have a right to pursue their case, and especially when you have some information that's clearly extremely relevant, which is mom's text messages to child, what she's telling him during these visits.
Thank you. Anything else, Ms. Jefferson?
Yes, Your Honor, I don't remember any of those statements being in her declaration, so I guess I'll defer to the court's memory on that. In any event, it looks like we are in agreement that her client cannot review the discovery. We're agreed then on time limits. And it sounds like we're agreed that the text messaging will be between mother and child. Is that correct, counsel?
No, those are things I offered to try to solve the problem before getting here. I think my client should be able to review it. I don't think it's reasonable. If the court wants to limit it, he can't take it out of my office. That's fine. Again, I was making every effort to find any solution, and that is part of my declaration previously, but my client should be able to review the information with me. He's not going to be able to remember, like if the concern is tracking or something of that nature, he's not going to be able to remember a bunch of GPS coordinates when he leaves my office. It's just not a reasonable fear. It has to be reasonable. The argument isn't.
And Your Honor, that's kind of one of the issues that we're having here is during the 26I, these were agreements. And then it's like, oh no, that's not the agreement anymore. And a motion is brought saying, oh, sorry, there's no agreements. It's getting ridiculous at this case. In any event, the information that's available to the public has already been turned over to opposing counsel. So now we're only talking about information that is not available to the public. We're talking about text messages. Obviously, the public doesn't have access to every text message you've ever sent or received. Including from medical professionals. And counsel's right. I could have decided not to look at what was there and just slid it into a disk to turn over. But I had to make sure that there wasn't privileged information there, that there wasn't confidential information there. And there was. And that's the reason that I had to go through it all. We are talking about all these text messages potentially, as far as doctor's appointments. More importantly, some of the issues is the medical conditions of other children. The obvious example is the sibling that lives in the house. There is a ton of it in there. We already had the agreement to the text messages between mother and child or messages in general. We had these agreements and then opposing counsel says no. So if she's fine with that, then I just ask that we put it into writing. It's on the record. So there's no confusion moving forward. Thank you, Your Honor.
And I just want to be clear, we didn't reach any agreements. If we had reached them, this wouldn't have been necessary and we wouldn't have a motion hearing. I wouldn't have filed to compel. She wouldn't have filed for a protective order. So sort of the fact that we had 2 motions about this certainly belies that there was an agreement.
All right, here's where I am at. I think that I'm falling kind of in the middle here. Request for production number 1. I think I am going to limit that to January 1st, 2021. And I do think that should be provided. Request for production number 3. And I guess just for my knowledge, so anytime they Google something, this is what that you're asking for?
It's only
Yes.
it'd be if you were logged in. So I don't think it tracks it otherwise. So if you have like a Google account, if you were logged in when you did that, yes. But other people have Google calendars and a whole bunch of other things under essentially their Gmail account. And so that's the type of things that it would get at. And that's frankly, I don't really care what they Google.
No, it's location and everything that they Google.
Okay, well, I'm going to limit that. I'm going to allow that and limit it to January 1st, 2021 moving forward. The number 5. Sounds like that's already in process. Is that correct? There's just concerns about,
Sorry, let me take a look.
I'm sorry, that's the messages between Jaden and mother.
Your Honor, we've already provided that. They want text messages between Jaden and everyone he's talked to since 2021.
Okay, so this is specifically just Jaden in general. Sorry, I misread that.
And that includes also messaging on his social media, which the court already denied them access to.
And to clarify, my client asked in a parenting plan to have access to his passcodes and to be able to monitor it. That's what the court denied, not that we couldn't get it in discovery.
Okay, so number 5, I'm going to, that should be provided. And number 6, that's already limited from January 1, 2021. That should be provided. However, that information shall not leave the office of Baldwin Legal Services. I do have some concerns based on Ms. Jeffers' filings that Mr. has and may use information that is found out, especially towards the child on some of these. So I think that he should have limited access to specifically view those. I think obviously Ms. Baldwin can relay to him the information in some of these texts, but for him to just have direct purview of all text messages that involve the child when frankly, there's been messages provided that he's used that specifically against the child do cause concern for the court. So I think I guess I don't want Mr. Rance to just be able to sit down in a room in his own in the law office and just review all those text messages and be able to make notes about what was said. I think that information should be gone through with his attorneys present to ensure there's some limitations there. I will say that I do understand Ms. Jeffers and her client's concern with some of that information being negatively utilized. And I don't really appreciate, just for the record, the communication between dad and child that was attached to this concern. So I do just want that noted. So and frankly, if further down the line we find any evidence that shows dad utilized specific messages that were discovered as part of this request to negatively speak with or influence the child, then that's probably not going to be looked at too kindly by the court.
And Your Honor, I'm sorry.
No, go ahead.
I just want to clarify. So, okay, they get the messages for everybody the child talked to. With regard to mother's messages, you indicated that they need to redact anything that does not involve the child. Is that correct?
I understood the court just said that they need to provide it.
That's correct.
Okay, so you're saying her medical, any privilege stuff or information about other children or children's medical conditions need to be turned over and not redacted?
You can certainly redact anything that's truly privileged. That means attorney-client communications, not discussions about attorney-client communications. But if she texts Mrs. Jeffers or her staff, that could be redacted and certainly provided with a redaction log or privilege log.
It doesn't allow for any exclusion of attorney-client privileged communications. If there's, I guess if there's a text message specifically about some HIPAA type items that relate to somebody that's not at issue in this case.
There are.
Which would be an interesting thing to text message about, frankly, but if there is that concern, I don't know that as long as there's some kind of certification of what's being removed, I don't have any problem with specific medical information about other children in mom's home being redacted. Or I guess, you know, other family members, like if it's her mother's private medical information, or, you know, it doesn't need to be just other children, but if it's not related to her or the child in question here, I think it, as long as it's noted what and why. Okay.
So a couple, just clarifying. So my client can view the documents and materials in my office, needs to do that essentially with supervision. And then just to clarify, the exceptions would be obviously if I utilize those materials and file them, that would be an exception. So if something is raised, something, you know, I find something that's, you know, wild or inappropriate and it results in a motion, my client would be provided with a copy along with everyone else.
Yes, that's fine.
And then Ms. Jeffers, it was her motion, so she can draft on for the 7th, if that works with Mrs. Jeffers, because we have another hearing on the 7th.
That's correct, Your Honor. That'll work.
All right, over to the 7th at 1 o'clock.
All right,
Thank you, Your Honor.
Thank you. We can go off the record. Thank you, Ms. Wade. I appreciate your patience.